Good morning, everybody. Happy Monday. Welcome to the Courtroom Files Live. Good to have you all here. We're going to start in Lenawee County, Michigan. Judge Anzalone, she is doing front of the court show cause hearings. So these are people who aren't paying their child support.
You've had a prior show cause. Last payment we received was $43.62. I don't have a date on that, but payments, we've received payments of $489.24 total since July. And so, sir, are you still working at the same place?
Yeah.
All right. For some reason, we haven't gotten any follow-up on the income withholding. So it looks like you are going to have to keep...
My caseworker said everything's in place. Everything should be all right. I just talked to her.
Hold on. She's logging in right now.
Okay.
So let's see what she says. All right, Miss Kim, this is Mr. Donald. He said that he spoke with you and the update is that the income withholding is in place.
It's not currently. It is for his other two cases, but not for this one. But there is payments being made.
Okay, so it looks like Mr. Donald, you have a couple cases. And so this one, they can only take so much money out of your paycheck for child support.
Yeah.
So if they don't take out for this, you're going to have to make the payment either online or in person. Okay.
Okay.
Your Honor.
Yes, Miss Kim.
This case is in arrears only.
Yes, it is.
So he would have to make sure it's designated for the case. Otherwise, it'll go to number two.
Right. So, Mr. Donald, do you live in Lenawee County?
No.
Okay. So, how does he do that? I mean, I think the state, even when I have people designate, the state puts the money where they want to.
Exactly. Unless he has a family member or something that could drop it off for him here.
So, Mr. Donald, like, how far are you from Adrian?
About 2.5 hours away.
Yeah, you don't have family here?
Not that would be willing to do any of that.
Yeah, Miss Cam, could he mail in a certified check?
Email.
You can mail it to MISDU.
But won't it still separate it the way they want to?
Right.
We don't take certified checks or money orders?
No.
Or I'm gonna have to check. That's probably, okay. Well, he has no way to get it here. He lives 2.5 hours away.
I understand, Your Honor.
Okay, so Mr. Donald, I'm actually gonna try to talk to the head of the front of the court about that and see if we can accept like a money order or something. Because unless you make the minimum required on all your cases, no money is gonna go to this one.
Okay.
So, I mean, as long as you're making your minimum on those other cases, I think it'll go to this one too, won't it, Ms. Cam? Stevenson?
Your Honor, we might actually have a special instruction payment coupon that he can use to send a money order in. I'll have to look through, but I think we do have one where he could use the special payment coupon, send it in here, and it can be applied however, which way.
Oh, excellent. So can Ms. Cam mail that to him? Some copies?
Yeah, have him contact her just so that we have all his contact information, but I'll go ahead and look for that and give it to her.
All right, so Ms. Cam, I'm gonna put you in a breakout room with Mr. Donald to get his address and make sure everything's up to date. And then if you could mail him like 15 of those special coupons, then he can actually mail his payment in it with a money order or certified check, all right?
Okay, thank you, Your Honor.
All right, so Mr. Donald, I'm gonna set this over to November 17, just to make sure we were able to get everything in place. I'm gonna put you in a breakout room with Miss Cam.
Okay.
And then she's just gonna make sure we have your right address and everything, and then look for in the mail those special coupons, and on the coupon is the address to mail it to, and just make sure you're doing that and we should be good. All right.
Okay. Yep.
All right. Thank you, Mr.
Thank you.
Donald. Okay, join the breakout room, and when you're done, you're all set. All right, Mr. Robinson. Mr. Robinson, whenever you're ready.
Okay. Hello, how are
All
you?
right, I'm good, thank you. So this is in the matter of, let me get back there. Candace Grisham versus Douglas Lee Robinson, file number 17-44257UE. So Mr. Robinson, it looks like you have a monthly charge of $222. At the time of the original show cause, you owed $12,540, and as of today's date, you owe $13,671. We have not received any payments since then. The last payment received was $141.42 back on November 15 of 2023. This is your third show cause. So if you were to plead guilty or be found guilty, you could be facing up to 90 days in jail. So, Mr. Robinson, are you currently employed?
No, I don't know if you remember or not. But I was in jail for I've been going, had some court dates for some other charges. And you gave me that $500 bond, which I did pay the bond, the
Yeah,
500.
you did.
So, I could forfeit that to start with. The
I'm
truth is,
pretty sure you already did. We take that money usually.
well, actually, I got to go turn myself into Washita County Jail for violation of probation. And I'm not sure exactly what they're going to give me. I'm going to,
Circuit court or felony, or circuit or district court.
it's just a misdemeanor.
But my question was, do you have a job?
Oh,
Do you have a job?
self-employed.
Okay.
Self-employed.
Okay, I'm just saying, if you're self-employed and you can't pay your child support, it's probably time to get a different job. All right, so what
Yeah.
I'm gonna do is, I'm gonna set this over to November 17 for you to take care of your warrant out of Washtenaw. But sir, you either get a job or make a payment, all right?
Yes. Now, if I'm in jail, still, will you guys know that where I'm at, or do I need to have somebody contact you?
Probably have somebody contact us.
Okay, awesome.
All right, good luck. Thank you.
Thank you, ma'am. Have a good day.
You too. Mr. Laura, if you can, there you go. Thank you, sir. So this is in the matter of Jennifer Lohr versus Kyle Lohr, file number 2013-38954DM. So Mr. Lohr states here you're ordered to pay $299 a month in child support. As of our last show cause on March 26th of 24, you owed $39,717. As of today's date, your rearage is $40,112.10, which means that at least some payments have been coming in because it hasn't gone up substantially. The last payment we received was $4.86 on August 29 of 25. And we haven't received any payments. So Mr. Lohr, are you currently employed? We didn't hear a response, sir.
But I'm paying a screenshot of it.
Mr. Lohr, we can't really hear you, so I don't know if you can go somewhere where you have better reception.
Yeah, I'll try.
Oh, that's better. So, are you currently employed?
No, ma'am. I made a $2.99 payment on Friday. I have the screenshot of it.
$299 online
Yes,
or,
Yeah, it was online on Friday.
okay. Do you have any other child support cases?
No.
Okay, so Mr. Law, your monthly charge is $299, but you gotta pay extra on that or the arrearage is never gonna go down.
What number would be a good number for me?
Usually like $350, we like at least $50 extra.
Okay.
Okay, so you're not employed. Is there a reason you're not employed?
The VA has rated me at 100% for totally and permanently disabled for my service.
Okay, do they pay out to your children?
No, it pays directly to me. I just need to make more payment, like you said.
Okay, so Mr. Lohr, I mean, obviously, you know, this is probably wearing on you, but yeah, you need to pay $350 a month, so you still gotta make September payment, but you made
Okay.
$299 Friday. So you need to start, what day of the month do you get paid?
The first.
You get paid the first. So I'm gonna set this to November 17 at 8 AM. So I
Okay.
expect as soon as you get paid, you make a payment. I mean, if we have payments coming in, we're not gonna keep dragging you back.
Okay.
All right?
Yes,
So
ma'am.
November 17 at 8 AM. Thank you.
Thank you.
Did you tell her?
Yes, honey, I did.
Who's asking? That you're.
I told her all of that. I just told her all of that. Yes, I did. That's why she said, no, the payments are $299. Like your arrears is.
That was funny. Good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Monday. Let's head to Texas. Judge Stevens, see what's going on there.
With your attorney, Mr. Adams, and the state's attorney, does the defendant waive a formal reading of this? I guess it's a motion to revoke unadjudicated probation that's been pending for what, 300 years? And since 2022, anyway, it's a long time. It needs to be moved. And can we proceed in summary?
Yes, sir.
Right. Sir, raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
So,
Lower your hand. In summary, this motion states that on June 24th. Okay, we have a mistake here. Any any objections to correcting the year?
should be
See.
2019.
This says 202019.
Yes, well,
Okay.
actually strike out the first 20.
Uh-huh.
Must have hopped in my DeLorean and went ahead and,
Again, in summary, this states that on or about June 24th, 2019, you were placed on 5 years deferred or unadjudicated probation for the state jail felony of theft. Is that true?
yes, sir.
Says, one, you failed to report to the Jefferson County Probation Office on or about February 22nd, 2022 in violation of your probation order. Is that true?
Yes, sir.
And three, you failed to comply with the program guidelines and rules of the Substance Abuse Felony Punishment Facility Program by not attending the Milton Center Safe P Outpatient Aftercare on January 21st, 2022. Is that true?
Yes, sir.
Are you pleading true? Let's just go with those.
Yes, sir.
To allegations 1 and 3 of this motion to revoke probation voluntarily and because those are true as they are alleged.
Yes, sir.
Do you understand that a knowing and voluntary plea of true to 1 or more violations of probation, that's all it takes to grant a motion to revoke probation. Your probation can now be revoked. You can be found guilty and sentenced up to the full range of punishment. It's just.
The state jail.
It is a state jail.
Yes, sir.
a state jail felony, which means you are looking at being found guilty, then sentenced to no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you were pleading true voluntarily. Do you understand and appreciate the consequences of pleading true?
Yes, sir.
An agreement's been reached where you would be pleading guilty. I'm just going to put 1 year. Is that good? We're seeing sometimes when they get a 12, they inadvertently take that's 12. You would be making your pleas of true to these allegations. Your probation would be revoked. You would be found guilty of the state jail felony of theft, sentenced to 1 year in the state jail. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand? Here, he needs to sign the bond. Do you understand it? You have no right of appeal, and that needs to be signed there.
Sorry, do those cuffs on and.
Once again, do you understand? You have no right of appeal here, sir.
Yes, sir.
Okay, and you signed that. Also, you're going to be given credit for all time you have served. I'm going to follow this agreement, and thus you have no right of appeal. Okay. Anything else to add by anybody before I make final findings?
No, sir.
If not, I'm going to find that Mr. Cawley, you have pleaded true to allegations 1 and 3 voluntarily, knowingly, intelligently. That is enough to grant this motion to revoke probation by a preponderance of the evidence or greater. Thus, your deferred or unadjudicated probation is hereby revoked. Earlier in this case, you pleaded guilty to this state jail felony of theft voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at that earlier plea hearing to find you guilty beyond a reasonable doubt. We deferred your finding of guilt and placed you on deferred or unadjudicated probation. Now that probation is revoked, I hereby find you guilty beyond a reasonable doubt of that state jail felony of theft. And I am following this agreement. You are hereby sentenced to confinement in the state jail for 1 year and given credit for all time served in conjunction with that case. Do you understand what has happened? Okay.
Yes, sir.
What are you going to do now? When when this is behind you, you get out.
Give me a job.
We're doing what?
Give me a job.
I mean, doing what? What kind of things do you do? You got an idea, I'm sure, right? Do you have a lot of talents? Do you have skills?
I like to play sports.
Do you like to
But
play
right now,
sports?
my brain I can't think straight right now.
Well, that's a fun. Have you thought about going to law school then? I'm just kidding you about that. I just wanted to see if the lawyers were listening. That was just, I went to law school too, but actually, if you're capable and that's what you want to do, there's an old saying, you can do anything with a law degree except practice medicine. It's a great degree. But what is it you like to do? For, that helps others, that makes a living, where you make a living. Mechanics, you fix things? No? Well, you gotta have a plan. Well, you're thinking about it. You're thinking about a plan. You gotta put one together and then do it. Okay. But the most important thing is stay out of trouble. Right. Okay. Good luck to you, sir.
Thank you. Good luck.
Okie dokie, let's head over to Florida. I believe Wade Mercer is doing his first appearances. Let's see how the weekend was down there.
Your criminal history is not bad at all. But I am concerned, under employment, the pre-trial release sheet I've got says that you are.
Judge, if you recall, he's severely mentally. I don't recall anything at all about an accident about 10 years ago. Okay. Remember, if he's the one that's severely brain damaged.
Okay. All right. So, Mr. Odom, I'm going to ask your mother a couple of questions, Mr. Odom. Ma'am, does he receive some type of disability income?
Yes, sir.
Okay, so he's legally disabled? Okay, and he's not able to work. That was my question, is whether he was employed or not. He's not able to work because of his disability. Is that right? All right.
I have power of attorney over him, and he's not. He can't work.
Who does he live with? Who does he live with?
He lives with his fiance, and he's on like 7 different medicines. I have to get to him, distribute to him. He lives like, not even a mile from me. I check on him every day.
Who was the alleged victim in the battery case from last year?
Beyonce.
Is that case pending or is that case dismissed?
Dismiss.
I'm sorry, I can't hear. Someone else in the courtroom's talking, whoever it is, I can't hear. So was it Mr. Odom talking?
Yeah, I think.
Okay, Mr. Odom, I'm asking them some questions. So Mr. Odom, let me ask your family some questions, okay? I'm sorry, you were trying to answer that, ma'am. And that case is dismissed now?
Yes, sir.
Okay, and you were the alleged victim, right?
Yes.
All right, so Mr. Odom, now I'm going to listen to the attorneys and see if they have any additional information. Mr. McDaniel?
Yeah, we just asked for some kind of maybe cash bond option, something family can afford to get him out.
Mr. And you were the alleged victim, right?
Yes.
All right, so Mr. Odom, now I'm going to listen to the attorneys and see if they have any additional information. Mr. McDaniel?
Yeah, we just asked for some kind of maybe cash bond option, something family can afford to get him out.
Mr. Mitchell?
No objection to a cash bond.
Mr. Odom, I'm going to set you a cash bond of $250 based upon your criminal history. It's a $250 cash bond. That means when the $250 cash is posted, he'll be released. He has a condition of random urinalysis. So as long as he has a medical marijuana card, it says in the complaint. So if he's got something like that in the system that can lawfully be the result of a medical marijuana card, at least a substance that you can get with that, that's okay. But he can't have anything in his system, including marijuana, that is in excess of the amount you can get from a lawful medical marijuana card. There's some types of high-grade marijuana that are not legal to get with a marijuana card, I believe, and that will show up in your urinalysis. So he very well may be drug tested, but when they post a $250 cash bond, he'll be released. Does the family have any questions?
No, sir. It'll be about an hour.
Sir? He requested a cash bond. The problem with a conditional release is he has to report in weekly by phone. And I'm going to go out on a limb here and say that after talking with his attorney, he preferred the cash bond. So you don't have to, he doesn't have to report in. It has less rules to follow. Therefore, it's less likely for him to mess it up. Question? Okay.
If he wants a conditional release, someone needs to remind him he's got to call in. Also, this court date, I guess, maybe October 7th. Is that correct? Or are we on the new docket yet or?
No, I can't.
No,
For
this one's a felony.
felony. October 7th.
So I have no problem offering you a conditional release, but you need to understand, Mr. Odom, that on a conditional release, you have a lot more rules to follow than a $250 cash bond. Plus, a conditional release isn't free. It costs $30 a month. On a conditional release, you have to call in once a week. And if you don't call in, that's not like not reporting to a probation officer, and you can be violated and go to jail if you don't call in once a week. Also, on a conditional release, he not can be drug tested. He will be drug tested. On a bond, it may or may not happen. On a conditional release, he's going to be drug tested. He can't miss any court dates. He can't be charged with any crimes. So conditional release has a lot more rules to follow than a bond does.
We'll do the cash bond.
So your family says they're going to post the cash bond for you, Mr. Odom, and should be able to post it hopefully sometime later this morning. Mr. Odom, do you have any questions?
No, sir. Thank you.
Wish you the best, sir. Also, I'm going to ask the jail to give you a notice for your court date. Corporal Drown, October 21st at 8:30 a.m.
7th.
It's still 7th.
October 7th, I apologize. October 7th at 8:30 a.m. is his arraignment date.
October 7th.
October 7th at 8:30. They'll give you a written notice at the jail before you leave. He will not get anything in the mail. He's got to be in court in the other courtroom, October 7th at 8:30.
Okay, yes, sir.
All right. Wish you the best, sir.
All right, thank you.
Come on, Bo.
Yes, sir.
Apologies, a couple minutes ago we had a brief hiccup in the feed. Ellie has kind of zoomies going on, and she leapt onto the keyboard and closed out OBS. So unfortunately means we're no longer live on X or Rumble. Apologies to those viewers. We'll try again tomorrow, but we are back on YouTube. And Ellie needs to quit jumping on my keyboard.
filed a written motion to violate the terms of your conditional release. I signed that order at the end of last week. That was based upon your new charge, as well as I think perhaps some other things. So you've got no bond in that felony case. In the felony case, I'm going to ask the jail to make sure you get a notice for your pretrial that you already set for, which is October 21st. So you've got a pretrial in that felony case of October 21st, and you have no bond. In addition to that, you have a charge on today's calendar, and are we taking any action in that case, Mr. McDaniel?
Yes,
What's
sir.
that charge there?
Petty theft.
On the new petty theft that you're on the arraignment docket, I'm going to appoint the public defender's office to represent you and ask that you listen to your attorney, Mr. McDaniel.
Your Honor, I spoke to Mr. Perry in 25-478 MM. He's going to plea of no contest to the charges listed. The understanding he'll be sentenced to 60 days in the county jail, 1 day jail credit, $370 fine. There was no restitution. I mean, they took everything back at Walmart, so.
Excuse me, Your Honor, if I
I'm gonna
may.
give you a chance, Mr. Perry. Give me a second. Because I want to make sure Mr. Mitchell's on the same page, and we're going to see if you have any questions.
That is the agreement, and yes, he was stopped right there at the last point of sale also, so the restitution was recovered. So,
Mr. Perry, any questions about that agreement?
I did pay for what I had.
Yeah, I think the
paid-
state's in agreement with that now. Mr.
Okay.
Perry, any other questions?
No, sir.
Mr. Perry, is this, well, they're in agreement that there's no restitution owed. They're not in agreement that you paid for everything
yeah,
because you wouldn't be charged. I shouldn't speak for them. But Mr.
Well-
Perry, they're accusing you of petty theft. So if you want to enter this plea, then I'm going to go with it. If you don't want to enter the plea, that's okay too.
And Mr. Perry, like I told you before, you've got clear defenses in this case. I think, I'm not saying there's no way they're going to convict you of it, but you got defenses in it. But I don't, you've got a long history, so I don't know if it's going to hurt you. And, if you just want to get it over with, that's fine also.
I just want to get it over with.
Okay.
So is this a plea you would like to enter, Mr. Perry?
Yes, sir.
So I'm going to accept your plea of no contest to the new charge, 25-478 MM. The charge is petty theft. The judge is guilty of that offense. Mr. Perry sentenced you to 60 days in jail. Credit for 1 day you've already served, $370 court costs and fines are imposed. Mr. Perry, that resolves the new case. And in the other case, while you're waiting on the felony to get through with or get the court on the felony and get it seen about, you'll be serving this sentence. Mr. Perry, there's no probation in this sentence. You finish this jail sentence, you're through with this charge. Mr. Perry, do you have any questions?
Yes, sir. I have an Attorney Owens. I talked to him. I talked to him before you signed the warrant for the violation.
On the felony case, or are you talking about in the misdemeanor case?
The felony case, the felony case.
Okay, I'm with you so far. Go ahead, please.
And I was supposed to be in court on the 19th, but I talked to him the week before, and he told me that he was rescheduling my court date for October 21st. But they had
19th, you were supposed to be in court 19th of September?
Yes, sir. I think that was the date I was.
But I looked at your file. I'm sorry to interrupt you, but I looked at your file this morning and it shows your court date being October 21st, which is exactly what you're saying.
Okay, yes, and he gave me October 21st, and I signed a plea offer in his office the day that I had the appointment with him for that felony.
Clarence, do you have a question?
No more questions, though.
Okay.
So I'm double checking this one more time, and the clerk's office shows you having a court date of October 21st at 1:30 p.m.
Yes,
Secondly, whether or not this charge will change that plea offer, I have no idea. The state attorney's office may look at it and say, it's just a misdemeanor charge. It's not going to change the plea offer we made, or they may say this changes things, or it may not change it in their mind. It may affect the judge's decision whether or not she's going to accept it. So I can't tell you anything about that other than you've got court on that court date, and we'll see what happens. Any other questions?
Okay. No, sir.
Wish you the best, sir.
Well, he's between contestants. Barbara brought up a good point. We are indeed above 25,000 subscribers now. We crossed that mark over the weekend. We're at like 25,163 or something like that. So I did want to say a moment and say thank you to everybody for all your support. We're not quite a year yet, a few days away from that, and we're at 25,000. Very vibrant community, and really appreciate it. So thank you.
Is it one count of breach of the peace, one count of exposure of sexual organs, and one count of resisting an officer without violence? There is probable cause for these charges. According to the Department of Corrections website, you got out of prison in July of this year, which was 2.5 months ago. Mr. Nicholson, I'm going to listen to the attorneys and I'm going to address your bond or your release status. Mr. McDaniel, anything?
No, Your Honor.
And it's a bond analysis?
Yes, Your Honor.
Mr. Mitchell?
Nothing from the state, Your Honor.
Mr. Nicholson, given your history, I'm going to set your bond at $3,500 per count. You have 3 misdemeanor counts. That makes your total bond $10,500 cash or surety. I'm going to ask the jail to get life management to do an evaluation and make sure that you're not a danger to yourself or anyone before posting bond and being released. But you have the right to post bond, and you'll use the phone in just a few minutes, sir, to try to post that bond. Mr. Nicholson, do you have any questions?
They just offered me a plea deal. There's no possibility. There's no possibility. There's no possibility.
Mr. Nicholson.
This is your attorney talking. Go ahead, Mr. McDaniel.
Mr. Nicholson, did you want to accept that plea offer of 6 months in jail?
I was trying to figure out if there was a possibility for conditional release.
No, sir. It was clear to you. You didn't never respond to me when I asked you the question. So we just asked for the bond, Your Honor.
Okay. Yeah, you're not a conditional release candidate with your history getting out of prison 2.5 months ago, but you do have the right to post that bond, and you'll get to use the phone in just a few minutes, Mr. Nicholson, okay? Yeah, I do want the jail to give him a notice, please, for what date?
October 27th.
October 27th, and that'll be a 9 o'clock docket. 9 o'clock docket. Wish you the best, sir. Jeremy Bundy is next. Mr. Bundy, good morning. Mr. Bundy, you're here for first appearance accused of one count of battery. My criminal history, I did a little research this morning on what the jail sent me. It looks like you got out of prison in January of this year. Is that right, Mr. Bundy?
Yeah, beginning of this year.
So, Corporal, Mr. Bundy's date of birth, the jail date of birth does not match what's on the complaint or the criminal history or the DOC website. So, Mr. Bundy, I think all those are probably correct, and the jail's date of birth that they have for you is wrong, but I want to make sure. What is your date of birth, Mr. Bundy?
July 26th of 90.
Yeah, so Corporal, the jail showing July 19th of 90. So if y'all can get that corrected. So, Mr. Bundy, the good news is it looks to me like you're not on probation and you have no charges pending. That's great.
Yes,
so that means you're probably entitled to a bond. Let me see if the attorneys have any additional information before I set that bond. Mr. McDaniel.
Hey, I got a question.
I'll give you a chance in just a second. Let your attorney finish. You said nothing, Mr. McDaniel?
Nothing.
Mr. Mitchell?
Nothing from the state at this time.
Mr. Bundy, you had a question?
Is there any way I can get a conditional release today, man?
Not getting out of prison in January, no. But I will set you a bond of $3,500. I'm gonna set you a bond of $3,500 cash or surety. Cash or surety means you can go through a bondsman. Let's say you go through a bondsman, they charge you 10%. It would cost you $350 to get out of jail, Mr. Bundy. You got a condition, no contact with the alleged victim. Any questions, sir?
No, man, I can't afford that much on the bond, but I hope I can get it $300.
You'll get a chance to use the phone in just a few minutes. Hopefully you can post the bond. You'll be released. I wish you the best. We have also, we need to give him a notice for Corporal, if y'all give him notice for when, October 27th at 9 o'clock will be his court date if he's out of custody, that is. We have Christopher Salisbury, I think maybe the last first appearance case. Mr. Salisbury, good morning. Mr. Salisbury, it looks like you were first appeared this weekend and you were brought back today just to get you arraigned in the VOP they've told you about. So in the violation of probation in felony court, you've been accused of violating the terms of your probation, and the circuit judge down there has signed a no bond warrant. I want to get you a lawyer appointed if that's what you were asking for. Mr. Salisbury, do you want an attorney appointed to represent you?
Yes, sir.
I'm going to appoint the public defender's officer to represent you in that violation of probation. Listen to Mr. McDaniel, and then I'll see if you have any questions.
Your Honor, we're going to plead not guilty. As I said, this on October 9th pretrial. I advise you, Mr. Green, to go by and visit him, although he may have a different attorney for it by that point in time, since I assume he has a date, October 7th, also with the grand theft case. So on the grand theft, his notice should be for October 7th, and the violation of probation should be for October 9th, both of them at 8:30. Correct. I assume that they're probably going to take care of it on the 7th.
Mr. Mitchell?
That's correct, Your Honor, and nothing else from the state.
So Corporal, if you give him both those notices, I know he was first appeared only on the new charge this weekend, but go ahead and give him notice for both those dates. Mr. Salisbury, when they see you on the 7th, they very well may go ahead and take care of, get you arraigned on may see on everything. You may not have to come back on the 9th is what I'm saying, but that's the decision Judge Garcia will make on the 7th. But you've got no bond at least until then. Any questions?
No, sir.
All right, wish you the best, sir. Corporal, that's everything I had on my first appearance docket. Anything else from the jail?
No, Your Honor.
All right, well, since he's finished up there, let's go back to Texas, but say good morning to Judge West this time.
Able to get someone hired? Were you able to get a lawyer hired?
I talked to 3 lawyers, like you said. I talked to Lori Perezzo, her assistant Catherine. She said 5,000 through 7,000 was their price. I talked to Brittany Holmes, her, like that's the
Mm-hmm.
She said 3,000 to 5,000, and Dustin Garner is the one I'm considering going with. I talked to him through his main cell phone, and he said his prices was 8,500 to 3,500.
Okay. So how long do you think, do you have the money to try to get him hired?
Me and him discussed the case already. I talked to my uncle, which is the one who helps me pay.
Mm-hmm.
He said that I can, get to, like, I can go for him if that's what I want, because the man, everything he says sounds convincing.
Sure. So if I reset your case one more time, you think y'all will be able to get Mr. Galmore hired?
Yes, ma'am. If not, then I'll have to get a court appointment.
Sure. And so, I mean, you did everything. If you think you can afford him, I'll give you about 30 days or so to see if y'all can get that worked out. If not, when you come back, remind me of what you've done, and also talk to some others and bring me those names, because there may be some others that, go ahead.
Sometimes I be a little busy, because I called several ones before that, like,
they are.
Lori Perezzo, she was busy that day, because I think she was in court all day for criminal days.
Mm-hmm. You just have to keep trying them, but if you get him hired, bring the reset notice to him. If it's not going to work with him, talk to a few others, bring me those names, and then when you come back, we'll talk about a court appointed if that's not going to work out. Okay?
Yes.
All right, step in front of the clerk. She'll give you your reset notice. Kelby Blanchette. Good. Are you Kelby Blanchette?
Yes, ma'am.
And Mr. Blanchette, did you get someone hired?
Yes, ma'am.
Who'd you hire?
All right, Kendall's.
Is he going to be here this morning?
No, ma'am.
Did you pay him money?
Yes, ma'am. He gave me a receipt. I don't think he's gonna get it up, but he gave me a receipt.
Huh? He is. So do you still owe him some money? Is that, when are you going to get that paid?
Friday, next Friday.
Okay. So did he say he would, I'm thinking you probably need to get him paid off and then he'll send us the paperwork.
And I own like $200.
Right. So what I'm going to do is reset your case one more time. That'll give you time to get him all paid off, and then he can file the paperwork, and then that should take care of it, okay? Make sure you get that done and get a receipt and bring it with you next time, okay?
Can I have excuse for work?
Yes, sir. Ask the clerk. And if you'll make a notate, go ahead. At the bottom, if you'll make a notation that it's right and that he's already made a payment. Please, ma'am. Kevin Calise. Good morning. Are you Kevin Calise? And Mr. Calise, this is your initial appearance in cause number 24, DCCR 1948. You're charged with theft of property from July 1st of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Did you get someone hired already?
I've talked to somebody, but I'm willing to get somebody hired.
So what I'll do is reset your case about 30 days to give you some time to try to hire somebody. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of who you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? All right, step in front of the clerk. She'll give you your reset notice. Diamond James. Good morning, ma'am. You're Diamond James. And did you get someone hired? Speak up, please.
No, ma'am.
Who'd you talk to?
I spoke with Kyle Walker, he said 7,500, but no payment plans on the down payment.
Okay.
I spoke with, is James or Macon?
Mm-hmm.
They said 7,500 as well. I spoke with Franklin and Associates. 10,000, the minimum is 7,500. 500 every 2 weeks, but the way the work has been going, the hours have not been 8 hours a day, so.
Right. So thank you for doing what I asked you. I'm going to let you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely because you're going to swear under oath that it's all true and correct. So put whatever your bills are, whatever your income is, and then I'll take a look at it. If you step in front of the clerk, she'll give you that those instructions. Kingston Walker. When did you ask for a tech? How long? I was about to say that's been 35 minutes. Good morning. You're Kingston Walker? And Mr. Walker, you were previously here and given some time to hire a lawyer. Did you get someone hired?
I spoke to multiple lawyers and I chose a lawyer, but I just need time to afford the payment.
Who'd you talk to?
Burbanks.
Okay, and you're planning on hiring Mr. Burbank?
Yes, ma'am.
All right, so, and you're working?
Yes, ma'am.
Okay, so what I'll do is reset your case about 30 days to give you some time to see if you can get him hired. If you do, just bring that reset notice that you get today to him in his office and they'll tell you what to do. If for some reason it's not going to work out with Mr. Burbank, then I'm ordering you to visit with at least 3 others. See if one of those works out. If fine, great. If not, bring me those names so I know you're trying, okay?
Yes, ma'am.
All right, step in front of the clerk. She'll give you that reset notice. Tyron Williams. Good morning. You're Tyron Williams? And Mr. Williams, did you get someone hired?
Benjamin Jeffries, but I'm still trying to get some money together.
Okay, so you're planning on hiring Mr. Jeffries. Have you made any payments yet or not?
I want half of it before he started doing anything.
Okay, so what I'll do is reset your case about 30 days. Your case is getting old. It's indicted some time ago, and the offense date was obviously early last year, so you need to try to get him hired if you can before that next court date.
Okay.
If it's not going to work for some reason with Mr. Jeffries, make sure you talk to at least 3 other attorneys. And if you can't hire any of those, bring me those names so I know you're trying and we'll discuss your options. Okay, step in front of the clerk, and if you'll put Jeffries on there as well, please. Thanks. Diamond Ollie.
Relatively tame Monday fashion show there so far. I'll keep an eye on it. Let's check into Miami-Dade, see what's going on there.
The defendant pulled a gun and put it on the back of the victim's head. It's an aggravated battery with a firearm.
Right, but there's no age, so I think that would be the more appropriate charge.
Agresión física con agravantes. Agarró la pistola y la puso detrás de la cabeza de la persona. Así es, dice la fiscal, pero no dice la edad. Ese sería un cargo más adecuado.
So you are ordered to stay away from the alleged victim, Jesus Marrero.
Señor, se le ordena que se mantenga alejado de la presunta víctima, Jesús Marrero.
No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
No contacto con la víctima, ni directo, indirecto, en persona, por escrito, por teléfono, ni a través de terceros.
No contact with the victim through social media or other electronic means.
No contacto con la víctima a través de redes sociales o ningún otro medio electrónico.
And you must stay at least 500 feet away from the victim, his home and school and place of employment at all times.
Y permanecerá en todo momento por lo menos 500 pies alejado de la víctima, residencia, su escuela o su lugar de empleo.
What bond are you seeking? You want 5,000?
5,000 is good.
$5,000 bond.
$5,000 de fianza será su fianza. Que tenga buen día.
Next is Ashley LaGuardia Ibanez. Good morning. So you were arrested for aggravated, Spanish, please. You were arrested for aggravated battery. I will appoint the public defender's office for you.
Señor, lo han arrestado por agresión física con agravantes. Voy a nombrar a los abogados de oficio que lo representen.
There's probable cause for aggravated battery.
Hay motivo fundado para el cargo agresión física con agravantes.
So you are ordered to stay away from the alleged victim, Yurandi Hidalgo Hernandez.
Señor, se le ordena que se mantenga alejado de la presunta víctima Urandi Hidalgo Hernández.
No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
No contacto con la víctima, ni directo, indirecto, en persona, por escrito, por teléfono, ni a través de terceros.
No contact with the victim through social media or other electronic means.
No contacto con la víctima a través de las redes sociales o ningún otro medio electrónico.
And you must stay at least 500 feet away from the victim's home, school, and place of employment at all times.
Y en todo momento permanecer por lo menos 500 pies alejado de la víctima, su residencia, escuela o lugar de empleo.
Do you understand the stay away order?
¿Entiende usted esta orden de alejamiento?
Stay what
Conteste.
bond do you want? You want 5,000? What do you want? How long have you lived here in Miami, sir?
¿Cuánto tiempo lleva viviendo aquí en Miami? ¿Cuánto?
10 años.
10 years.
$5,000 bond. Have a nice day.
5,000 será su fianza. Que tenga buen día.
Next is Joseph Cruz, page 6.
Judge, can Mr. LaGuardia Ibanez go back to the location to get his?
With a
belongings?
police officer, he can go with a police officer to get his personal belongings.
The interpreter can translate, please.
I'm so sorry. Puede regresar a la casa para retirar sus pertenencias acompañado por un agente de policía.
The business.
Al negocio, disculpe. Puede regresar al negocio.
Okay, sí, gracias.
All right, next, Joseph Cruz, good morning, sir. You were arrested for possession of a controlled substance called crystal meth. I will appoint the public defender's office for you. There's probable cause. Will pretrial taken? Yeah, pretrial services alternate bond, $2,500. Have a nice day. Brandon Alvarado. Page 7. Good morning, sir. You were arrested for possession of a controlled substance, a public nuisance, and resisting an officer without violence. Do you speak English?
Yes.
Right, I will appoint the public defender's office for you. It's possession with intent to sell methamphetamine. Not possession, 13 grams of it. You're ordered to stay away from the House of Horrors at 1625 Northwest 107th Avenue in Doral, Florida. You're not allowed to go to that location, that House of Horrors, and stay away from there. You understand? Yeah, 13 grams is a sale amount. I'm setting up on count 1, the possession of the controlled substance. What do you want me to do?
Okay, so it's an F1, I believe, based upon the weight. Would you want to do 7,500?
Trafficking? It's a
It's
trafficking?
not trafficking, it's possession over 10 grams.
Oh. Count 1 is possession with intent to sell a
Sorry, Judge, what was the bond account one?
I'm still figuring out, I'm running my findings here. It's a first degree felony?
I believe so, yeah, over 10 grand.
$7,500 bond, count one. Count two, the nuisance charge, be $1. Count three, resisting without. It's $500. Good luck to you, sir.
Mr. Alvaro is asking if your office could get the substance tested as soon as possible. Please.
You want me to do house arrest as an alternate? It's 18.
Yes, please. Or I don't know, would you consider pretrial, Judge? He's
No.
got no history.
Nope, nope, nope. House arrest with a GPS monitor, alternate bond, 7,500, count one, $1, count two, $500, count three. So you can get out for free with an electronic monitor on your ankle or post the bond. So it's level 3 house arrest. And let me give him a curfew, 11 p.m. to 6 a.m. Have a nice day. Next, Bruno Rodriguez. Good morning, Mr. Rodriguez. You were arrested for possession of a controlled substance called 2CB, possession of MDMA, and possession of drug paraphernalia. Do you speak English? I will appoint the public defender's office for you.
So there's no description in the narrative.
Oh.
I don't know if it's Corey wants to
Reset
wait.
for probable cause hearing. What's up with the officers?
I don't know, but if you want to waive the issue, we could do pre-trial.
Just reset it. Next, we have Kevin Lopez. See you later. There's no probable cause. They got to bring the officer in. KJ, Kevin Lopez.
Yeah, no, is he allowed to bond out?
He's allowed to bond out if he wants. Bless you. Do you have the next person, Kevin Lopez?
Judge, Mr. Rodriguez is asking if you would consider pretrial services now. He'd like to get out now if he could.
All right, sure. Do you have it back?
We'll
I
waive
think you
probable cause argument.
Yeah, to start bringing these officers in. Maybe then they'll write the arrest affidavits, right? And then we'll have to do this. So I'll give him, sorry. Pretrial services, alternate bond, $1,000, count one, 1,000, count two, and $500, count three.
Thank you.
You may be eligible for the drug court program as well, sir. It's something you should discuss with your attorney.
All right, we'll keep an eye on Miami-Dade. Let's go up to Michigan. Judge Mom, Judge DeSanto, see what's going on with her.
Yeah. I'm sorry. I'm not understanding who it is says that you're working with.
Paragon Systems.
I understand Paragon Systems, but I'm not understanding what it is you said that you're doing there.
Okay. Well, I write for the client and just do, other things for the client. Mm-hmm.
Okay. Paragon. And ma'am, if you were to test right now, what is in your system?
I work for Obi Warmat with Paragon Systems.
I'm sorry, you what?
I work for Obi Warmat with Paragon Systems. Mm-hmm.
What you work with what?
I work with Obi Warmat and I writing for him. Mm-hmm.
O-B What?
Obi Warmack.
O.B. Borman?
Warmack. WARMACK. Warmack.
Warman. Okay. Ma'am, if you were to test right now, what is in your system?
There's nothing. You can test me. There's nothing in my system. I don't do drugs. I don't do any drugs.
Are you under the supervision of a treating physician?
Yes, I've gone to Lincoln Park Medical Center there. I was hit in the face, basically punched in the face by this black man. I don't know why this black man is here now with the black, but this black man who attacked me because I'm a writer, and he punched me in the face. So my teeth were dislodged, so I had to go. I have the paperwork is in my folder there that they have in the front. That paperwork is there showing that I went to Lincoln Park Medical Center, and they then sent me for x-rays, and I have to see a dentist as well. So I am under their, yes. And I've gone to them for other things as well. They've given me a letter for my service dog because I have a service dog. And
So, ma'am, I understand that you're a writer. How is it, well, who resides at the home with you?
I live by myself. It's my home. It's my home. It's a 3-unit building I converted into an art school. And I need to go home because, I met with my attorney on the home, and I have a meeting on Monday about the home that is imperative for me to be at. Yes. I don't know where the blocks are. The ones.
I can't hear what you're saying, ma'am.
Yeah.
Ma'am, I cannot hear what you're saying.
Know why the blacks are here that are attacking.
What's that? Okay, here's what the court's going to do. Given the nature of the charges, the court's knowledge of Ms. Choka, she was just here last year on a matter.
There's nothing like them.
And the observations of the court with Ms. Choka and what it appears to be her needs, the court's going to order a $7,500 personal bond. You are not to be released without a GPS tether, and the only way you're going to be released is to be tethered to treatment through the Wayne County Jail. So that's mental health treatment through the Wayne County Jail. You're not to have any contact with Bacon Library staff, and you're not to return to Bacon Library in the city of Wyandotte, and you are not to possess or consume any alcohol or drugs that are not prescribed. We'll see you back on October 8th.
I don't understand. So what's happening right now?
Ma'am, you're going to be tethered to mental health treatment so you can have an assessment to see what services you are in need of.
So I'm going to be tethered and let go? Like
You're
I'll
going to
be
be-
out tethered?
No.
And
You are going to not,
on October the
Ma'am.
8th?
ma'am, you are going to be transported to Wayne County Jail. Wayne County Jail will process you through, find a mental health treatment facility for you, and then you'll be tethered to that mental health treatment facility for an inpatient basis.
How long will I be when will I be let out of Wayne County Jail?
Ma'am, I don't know how long it will take them to process you, to tether you to treatment. And then You will then be back here on October 8th, likely via Zoom, okay?
I need to meet with my attorneys for my home.
Okay.
All right, good luck to you, ma'am. Thank you.
Excellent.
So October 10th.
Have a good day.
Barbara, we don't know what her crime was. The judge started her feed like right there, right where I started, so I have no background on that. Conceivably some kind of mental health issue, but, you know, because the way our system works, they have to be in the criminal system before anybody gets any kind of help, and it's just a mess. I'll keep an eye on Judge Mom. Let's go back to Judge West.
Be like a blind man here shortly.
All right, so you're James Lofton?
Yes, ma'am.
And Mr. Lofton was previously in court. Now, the misdemeanor is something that, remind me, why do I have that
He
on?
was supposed to have pled to his misdemeanor several resets
Right.
ago each time prior to coming down here, because our plan is to have him, we had talked about
To extend
ISF,
probation and ISF.
But now it's for safety if the court considers based on this update PSI, but obviously we can't do that until he pleads to the misdemeanor.
Well, I can do that today, and he can go into custody, and y'all can go take care of it.
That's what I was just gonna.
Because he'll sit in custody until he goes and
Correct,
takes
that's-
care of that other case, because he
that's
won't go. All right. So in cause number 16-24485, first year James Lofton. Mr. Lofton was previously in court, and that is a motion to revoke probation. On probation for the third-degree felony of assault, family violence. It was a 5-year deferred at one point, and then in February of 2020, that probation was revoked and given a 10-year term that was probated for 5 years, so went to a straight probation, placed on high-medium caseload and zero tolerance. I've received the updated pre-sentence report also. Has everyone had an opportunity to review that report?
Yes, ma'am.
I have your own.
Any additions or corrections to that?
No, ma'am, the only thing I would say is since PSI is that we have, this last week, we have gone and taken a drug test at Beaumont Occupational, and my client has, is that I have those drug test results if the court would entertain.
That's not going to change.
Okay.
What I do based on the nature of that examination and the substance abuse evaluation, I'm going to follow those. I appreciate that he stayed clean for some amount of time.
Yes, ma'am.
But if I'm going to follow after what I just said with regard to the nature of where we've gone on this, he looks like there's a new misdemeanor, driving while intoxicated second, and that was from December of 2023. We're just finally getting here, so I'm going to do what's necessary, I think, if I'm going to leave him on probation to keep everybody safe.
Like I said earlier, Judge, Mr. Barrington and I had previously discussed after we both reviewed the PSI that safety may very well be in
Yeah.
the best interest.
That's what it appears from that evaluation, and so I mean, I rely on them and their
Yes.
evaluation to
Yes,
say
ma'am.
what's best and do, and they're talking about the not just the regular safe P, but special needs safe P, so that it covers everything from mental health to drug treatment to everything else that would be necessary, hopefully, for Mr. Lofton to finally be able to complete this probation. In addition, it will be, I will have to, and not just have to, but I will need to extend and plan on extending that probation period as well, because it's up either already or this year, and it's only pending because of the motion. Is that right?
Yes.
Okay. All right. So anything else with regard to that updated report or with me going forward with sentencing?
No, ma'am, other than the fact that he is working, I have his employer here, if you'd like to hear from them. We would ask that, the recommendation initially was ISF, and we would ask the court to consider ISF and sentencing instead, because he has been working with stable employment with his employer for more than 1.5 years now, has had stable housing as far as that goes, and so we feel like that him going to safety would cause, financially devastating for him. And so we would ask that he be allowed to go to ISF and then have more strict monitoring on weekly reporting and weekly drug tests with zero reporting.
Ms. Malfino?
I defer to the first discretion judge, just my review of the PSI. I think safety is probably going to be needed.
And so with regard to Ms. Jefferson, you initially also agreed that ISF with being on the high-risk caseload after would be appropriate. Is that your, what are your thoughts?
Yes, that was my initial recommendation. But I also included that I don't know much about his case because he had absconded for, I believe, over 2 years.
Yeah. And it looks like there was a tested positive for methamphetamine August 14th, last month, denied using it, but stated he had used a month ago, but tested positive for it. So I'm trying to see what specifically, why special needs?
I don't believe there was any sort of psychiatric.
I didn't see that
concerns.
either, so I'm
That's-
not real
That
sure.
was kind of what, the only question I had about it was.
I don't
is the
think we need-
Special needs is generally
It is, if there's
more
some
of a
type.
psychological type situation.
We don't have that, so
We
it's just
don't.
regular. Okay, so here's what I'm going to do. Mr. Lofton, I am going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. However, I am going to continue you on probation. I'm going to extend your probation period for 3 years. I'm going to order as a condition of your probation that you enter and successfully complete the SafeP program, not the special needs, but the regular SafeP program. And that you'll be on the high medium caseload when you get out. You'll be required to do aftercare. I don't know how to stress strongly enough that this is your last chance. You will not, if you are back in here, I'm going to look at this paper and I'm going to wonder what I did and why. So you will be required to have a drug patch on at all times when you get out. If there's one positive, you're back in here and looking at that 10-year term. You've already agreed to 10 years, no negotiations, no whatever. This is it. You violate, you're getting the 10 years that you agreed to way back when. Do you understand? Yes.
Judge, the only question I have is, I think he was put on probation in 2016, wasn't he? Is that, can we extend for 3 years?
Well, he was put on a deferred in 2016,
Okay.
and then he was revoked and given a straight probation in
Okay.
2020. So
All right.
actually, I could extend him for 5 more years
Got it.
instead of just 3.
Got it. Fair enough, Your Honor. Thank you.
I'm going to hand you the trial court certification. I need y'all's signature on that, showing that this was an agreement that I followed, and so you've waived your right to appeal. You'll go into custody. Obviously, Mr. Barrington will get it set up as quickly as possible for you to go take care of that other case down the hall in misdemeanor court, because until that's taken care of, you will not be able to go to SafeP. So y'all need to get that taken care of as quickly as you can.
Yes, sir. Yes, sir.
Thank you for being here. Thank y'all.
May we step over here?
All right, let's go back to Judge Mom. She has another interesting character, it looks like, lined up.
Mr. Johnson, would you please state your name for the record?
Jacob Johnson.
All right, thank you. And today is a date scheduled for the arraignment as your client is in custody. And counsel, as to the arraignment,
Yes, Your Honor. At this time, we are prepared to waive a formal reading.
the court will waive formal reading, enter a plea of not guilty for purposes of the arraignment. And we will schedule this matter for pretrial on October 8th. At 10:15 a.m. as to bond.
Yes, Your Honor. Mr. Johnson is currently living in Flat Rock. He is not on probation or parole, has no pending matters. He is gainfully employed at TB's Diner located in Trenton. And after speaking with Mr. Johnson, he did assure me he would be appearing at all future court dates, and he does understand the importance of doing so. I would just ask that all that be taken into account in assessing bond.
All right, Mr. Johnson. Who do you live with?
I live with my mother, my stepdad, and my daughter, Your Honor.
All right, have you ever failed to appear in court for any reason, sir?
No, Your Honor.
Are you on probation or parole anywhere?
No, Your Honor.
Are you out on bond in any other jurisdiction?
No, Your Honor.
And do you understand, sir, when the state tells you you are not allowed to drive, that you're not allowed to drive?
Yes, Your Honor.
And the ordinance violation you had in June of 24, did you resolve that matter?
Yes, Your Honor.
And if you were to test right now, sir, what is in your system?
Just marijuana, Your Honor.
Do you have a valid medical documentation regarding your use of marijuana or a medical marijuana card?
No, Your Honor, it's recreational. I
Yes,
used to
sir.
have a medical card, but I no longer have one.
Okay, yes, I'm very much aware it's recreational, sir. And that's why I was asking if you happen to have a medical marijuana card or any medical reason for marijuana use, so.
Not anymore, Your Honor, no.
All right, the court's going to order that you're not to possess or consume any alcohol or drugs that are not prescribed. The court's going to order a $3,500 bond on count A. I'm sorry, $3,500 10% bond, count A. $3,500 personal bond.
Personal bond?
Excuse
Your
me,
Honor? I'm sorry.
on count B. I'm sorry, what's that, sir?
Is there any way I could get a personal bond? I don't know if I'm gonna have enough money to get out.
Well, sir, here's the concern that this court has, right? You have, the court has taken into account your criminal history, one of which is a prior 8 years ago for operating while visibly impaired, as well as the other matters that are on your criminal history. And so the court has to ensure the safety of the public. And one way the court's going to do that is to have you post a lower monetary cash bond, sir, as well as you are to report to probation to schedule testing upon receipt or upon release.
Okay, Your Honor. Is there any way we could get my bond down to like maybe 100? 150?
Sir, this is the second time that you've had this charge. And so the court has concerns for the safety of the public. The court's not bartering on your bond amount, sir. The court, at a $3,500 10% bond, is a bit on the lower side. And the court will also note that that's a reasonable bond given the nature of the charges and taking into account the various factors that I've already stated.
Okay, Your Honor.
We'll see you back on October 8th. Have a good day.
Thank you, Your Honor.
Thank you, Judge.
Thank you.
Okay.
Thank you. All right. Let's go off the record for a moment. Did you bring in the
All right, well, she goes
how
off
could
the
you have already
record.
done?
Oh, quiet. Where she goes off the record, let's go back to Judge Stevens.
To be evaluated for competency. And Dr. Ed Rapon, licensed psychiatrist here, evaluated the defendant, deemed the defendant to be competent, and submitted a report dated August 28th, 2025. Had the parties had an opportunity to review it? And are there any objections for this to be placed into the record and sealed as part of the records in this case?
No. No objections,
Okay.
Judge.
It will be called and referred to as Court's Exhibit number 1 on this date.
Gotta hold that cell phone.
And in summary, Dr. Verpon deemed that Mr. Como is competent to proceed to his legal issues at this time. So it will be a part of the records in a sealed fashion. He has 2 cases.
Yes, sir.
24 CR 1735, the 3rd degree felony of evading arrest or detention. And then a more serious case in 25 CR 601, the 1st degree felony of aggravated kidnapping. Carries with it up to life in prison. So your next event is what? Who you want?
Just an announcement.
Okay. 4 weeks gonna be good to analyze and determine. All right, thank you. That is all.
Thank you, Judge.
Demarion Kelly.
Judge, he's right there. Come on up, Mr. Gillis. If you remember, we went for.
Oh, boy. Yeah, don't give me that. I remember things. There's 2,500 cases.
Let me give you a quick recap then.
Yeah, I remember him because he wears his turtleneck in the middle of the hot summer, which is an unusual fashion method. But hey, I like turtlenecks. I can't wear enough of them, but I only do it during the winter.
Judge, I believe it was last week or the week before. I think he did not come to court, or he was court like super late, but that was our first time coming to court.
Are you still at 2430 Jonas Way? Okay, I need to update where you are.
Right.
Where are you? Where do you live?
Cypress.
What's the number, sir?
What's your number for your address? Just, I look at it.
Go ahead.
You look at it.
Yeah, I gotta know this. This is the file needs to reflect your current address at all times.
And just while he's looking at it, I think that was last week on 9/23. He was late for court, and then you told him to be here today, being Monday, and I guess to see what was going on with him. But this is our first, well, that was gonna be our first time being in court, but I think when he was late, I told him to be here today.
There he is.
So.
And you're representing him.
Yeah, I'm representing, and I have given him, probable cause.
He's charged with the state jail felony of theft.
Right. And I do have an offer on that case too.
So that carries with it up to 2 years in the state jail.
Right.
Do you have a criminal history? No? This is the first time you've been in criminal trouble? Is that yes? You have to speak out, sir. So,
yes, sir.
All right, fix it. Just fix this.
The address is 147.
Huh?
14700. 14700. Vintage Preserve Parkway. Vintage Preserve Parkway.
Sounds like a nice place.
You don't have any criminal history?
I believe so.
And where is that? Houston?
Oh, yes, sir.
And the zip?
77070.
77.
Can you do 55?
Read that again. 77700?
77070.
That'll be lucky. A lot of sevens. Much time. Yes.
Yep. I think we'll move that one.
Reset 4 weeks, please. Get a resetting, sir. Thank you. Keep up with your lawyer.
Okay. Okay.
Cyrus Sandy. Hey, don't we have 2 add-ons here too?
Yes.
Is that right?
Yes, sir.
Are those Langston's too, as well?
Uh-uh.
Lamarian Bean and Jonathan Garcia?
No, that's not mine.
Okay, there's somebody wrote this in and tried to trick me. Trying to trick me. Yeah. Don, those aren't your cases, are they?
Yeah. Well,
Bean is Mr. Burbank's case, I know for sure.
Who is?
Martin Bean.
Okay, we'll put it then for next Saturday. Is Cyrus Sandy?
Hopefully before a happy hour, do it.
Is there a time? Is there a time on the clock that isn't happy hour for you? I don't understand. When would that be?
Oh.
Oh, look who walked in. He's delirious. Look at him. Where am I? Who am I? What day is it? Point me. Where's my car parked? And does anybody have food? Those are all the thoughts I'm getting from Rife. When do the inmates eat?
Yeah.
Yeah.
All right, Cyrus Sandy.
Thank you.
That's enough. That's an announcement. What are we gonna do?
Judge, was 2 off of 7 years and the off of 7-year cap. And I told him he's enhanced because of one prior.
Yeah, let's look at this, what we've got, what you're looking at. In 25 CR 537, you're Cyrus Sandy.
Yes.
It's Mr. Sandy. Are you still at 590 Center Street?
Yes.
You were indicted here on May 7th of this year. And it alleges that on or about March 2nd, 2025 in Jefferson County, Texas, you committed the 3rd-degree felony of fraudulent possession of more than 5 credit card or debit card items without the consent of the rightful owner. That's a 3rd-degree felony, which carries with it up to 10 years in prison. However, the indictment also goes to allege on paragraph 2 that on September 9th, 2019, out of the 76th District Court of Titus County, Texas. What's the Titus County? What would be what's the main city in Titus County? Mount Pleasant?
Mount Pleasant.
Mhm. All right. That on or about September 9th, 2019, in that district court, you were convicted of the 3rd-degree felony of illegal possession of a controlled substance. So if this is all true, this 3rd-degree felony punishment gets enhanced to a 2nd degree. So you were looking now, if convicted, no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000. Serious, obviously. What are we going to do today?
Judge, I gave him both offers, the 7-year cap and as well as 7 years. He said no to both of them.
Is that right?
Yes, sir.
And again, and it will be set for trial. There are no deals. The court will not make a deal. So we're going to move forward and get this thing tried as soon as possible. And of course, because of a prior conviction, you are not eligible for probation.
Yes, actually 4 additional state jail felony convictions as well, Judge.
Right.
Yes, sir.
Okay. All in a trial, all felony, if you're found guilty, all felony convictions can be used for punishment purposes for the jury to consider. And that is something they need to be aware of.
Not that big, yeah.
Okay, so you're gonna handle it on trial?
Yes, sir.
Okay, then so it shall be. Set for trial, no deals. Let's get this thing done as soon as possible.
No problem.
Derek Shepherd.
I sent you the paperwork.
Thank you.
Just go.
Derek Shepherd. There are no deals on that one. We're trying it.
I sent.
Message we send. Have a chance to think about it. You don't want to take this. Don't want to take a wise choice. We move forward. Derek Shepherd.
He's done.
Derek Shepherd.
He's coming back.
Yes, sir. Derek.
Yeah. Yeah, he's, 2 years.
Here's on Derek Shepherd's file, just put that in there so I don't forget. I'm no, not Derek Shepherd, Cyrus Sandy. All right, Derek Shepherd, does he need to be sworn into that lady first, sir? Thank you.
Yes. Raise your right hand for me. Okay. No, that's right. Sorry. I'm backwards. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah, depending on.
She said she was backwards. She said she was backwards.
Oh, you talking about that sign?
That's what Lacey said. I'm backwards.
Yeah, I think she can.
I didn't get my first was sloppy, that's fine, Judge.
That's the only question we have.
25 CR 978 is now called the State of Texas versus Derek Shepherd. That's you, present, with your attorney, Mr. Adams, and the state's attorney, thus the defendant, waive a formal reading of the indictment and arraignment here. Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about April 8th, 2025 in Jefferson County, Texas, you committed a third-degree felony of unlawful possession of a firearm by previously being a convicted felon. Do you understand what you are charged with here, sir?
Yes, sir.
This is a third-degree felony, which means if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? The agreement has been further reached. You would be pleading guilty, sentenced to 2 years in prison, and this is concurrently with an MPRP. Has that been done already?
Yes, Your Honor. And I think he was given 4 years on that.
Credit with credit for time served. Is that your understanding of the agreement?
Any time served, he says.
What do you say?
Yes, he said, yes, time served with it.
I don't know what that, I don't know how much that is. You would know, you get credit for time served that you're serving in conjunction with a charge that, like this one in particular. If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty? Oh, you're pleading guilty voluntarily. That is on your free will, your own free will, and because you are guilty.
Sir.
I'm going to show you what's marked here, States Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney?
Yes, sir.
Or the contents all true and clear? States Exhibit 1 entered into evidence?
No objection.
Without objection admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You were guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation by your lawyer. All true. So help you God. States Exhibit 1, part of the record for all purposes. Pre-sentence report is hereby waived.
Yes, sir.
I'm going to follow this agreement then, sir, and find according to the evidence you are mentally competent into your guilty plea. It is freely and voluntarily made. You know and appreciate the consequences of pleading guilty. There's sufficient evidence from States Exhibit 1 admitted here to support your guilty plea to find you guilty beyond a reasonable doubt of this third-degree felony of unlawful possession of a firearm by previously convicted felon. And I so find you guilty beyond a reasonable doubt of this charge. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years. You understand what has happened today, sir?
Yes, sir.
And anything else? That is all. Good luck for you. Yes, sir.
Thank you, Judge. Appreciate you.
You doing me the honor?
Oh, anytime.
First, sir. No.
Uh-oh. Uh-oh.
I've got. I don't have you. Where are you?
All right, let's change it up again. We'll go to Michigan. Judge Middleton doing misdemeanor sentences, I believe.
D. Burns, file number is 251318. This is a domestic violence case. I accepted the defendant's plea, set the matter for sentencing for this morning. wanted to get more information and victim input. We did get a restitution request. Jordan Harden is here with the defendant, and Angelique Camfield is here on behalf of the prosecution. Ms. Harden, what would you like me to know here?
Thank you, Your Honor. Mr. Burns did serve a good amount of time on this case at the upfront. Since release at the time of plea, he has gotten independent housing with his father, set out away from the complaining witness. They do not have a relationship, and he has no desire to continue such relationship. He is working. He works for Baja, which is a company that essentially sets up and tears down all the fair rides and things of that nature. So he's been busy lately with that. He does understand there's a restitution request and indicates today he's able to make a payment towards that, but would need a payment plan to finish paying that off. In my notes with Prosecutor Robert, because this plea was taken back on August 1st, we did set it out quite a ways. But Mr. Robert, at that time, my notes indicate had no objection to a time served just due to the amount of time he did up on the upfront. If the court did feel a probation was necessary due to the restitution component, I would ask for a non-reporting probation to ensure that that payment is made towards the restitution. Again, Mr. Burns has complied with all terms of bond. He has made no efforts to contact the complaining witness. He reports to me that she has tried to reach out over multiple social media accounts of his, but he has blocked her on those in an attempt to remain compliant with bond. He also, again, indicates no desire to continue a relationship with her. So I don't think we're going to see Mr. Burns again. He's done everything he's needed to do since he was released, and he's complied with all terms of bond. So I would ask the court to impose time served as well as fines and costs, and if probation is necessary due to the restitution component, that be done on a non-reporting basis. Thank you.
The defendant did spend 27 days in jail. I did a PR bond at the time of although at the time of the plea, he no longer had a right to have a bond, but normally, unless the defendant posts bond within 28 days in a misdemeanor case, they're allowed to have a PR bond. This restitution is actually for the apartment where the defendant was living, or the complainant was living. And there is a work order attached to it. Ms. Camfield, what would you like me to know?
Your Honor, my office will have to stand by the request for restitution and Mr. Robert's offer of credit for time served. I don't have
any additional input from the complaining witness.
I don't have a copy of the pre-sentence report, Your Honor.
There isn't one.
Okay.
I simply set it out. I want to get the police report. There's a video which shows him doing at least some of the conduct that resulted in his conviction. I didn't think we had any victim input, but I set it for this. The defendant is probably eligible for a deferral, but I don't think he's interested in it.
Well, we were interested, Your Honor. Mr. Robert said because he has a prior RNO on his record, he would not offer that. We're agreed to that.
Yeah, I can't do a deferral without the prosecutor's consent.
He was very much interested, but Mr. Robert was not willing to agree to that. So,
all right, if I knew that, I forgot it. Let me put a note in here: prosecution opposed deferral. All right. So do you travel with this job?
Yes, sir. Yes, sir.
No, you're here now. Well, you should be able to pay this.
I believe he did say he can make a payment today.
Yes, if needed to be, I'd be able to make a payment today.
All right, we're already 27 days credit, 27 days. There's a $75 fine, a $75 crime victims' rights fee, a $50 state minimum fee, $100 and $50 attorney fee, restitution of $400. I believe that goes to Gateway Village.
Correct, Your Honor.
That adds up to 775, I think. No, 700. No, 350, 750. How much can you pay today?
Probably like $50.
All right,
But next paycheck, I'd be able to do about 400.
all right, today. I'll make this due by December 1.
Yes, sir.
This will show on your record as a domestic violence, prohibit you from using or possessing a firearm for at least 8 years. I don't know if you like to hunt, but you can't in light of this conviction. Unless you have your firearm privileges restored. So at this time of year, do all those sort of things head south?
You talking about my
Yeah,
job?
your work?
It's seasonal, so yeah, so I would have to apply for another job, but I know we have two more this month.
All right.
So I will be able to.
I'll ask the court officer to take you out, you can make that payment. Make sure we got your correct contact information.
Yes, sir.
27 days, credit 27 days.
Thank you.
No victim input. All right, you're good to go, sir.
Thank you. Thank you. Can I hear your, you have a card? Sure. Okay.
All right, let's head back to Judge West. She has a new contestant.
Our intention, if the court would allow, is to have her enter the plea, do a PSI to kind of see where she is now. This was a case we brought over from CDC and then decide what is best on the motion. Either to dismiss
The
it or
burglary
to
of a hab
deny.
is the MTRP?
Yes, ma'am.
Okay, for some reason I said, before we go any further, I've got a note to remind myself, I have a seat in the jury box, I'm gonna get a drug test first. Hang on to it because it'll get mixed up with my other stuff. Please and thank you. Thank you. You don't want it to get lost in the abyss that I have going on up here. Ms. Cawthon, you have Zachary Turner.
Yes,
Good morning.
Good morning, Your Honor.
Morning, Mr. Coleman. Good morning, sir. You're Zachary Turner. And this is 24 DCCR 2197. Mr. Turner's charged with fraudulent use or possession of identifying information. And what is the announcement?
Your Honor, we're needing a reset. I've talked to the prosecutor and we're needing some more evidence.
There appears to be maybe some videos that did not make it to our file.
Okay.
And thereby not turned over to the defense counsel. And I'd like some time to run it.
Sure. All right. So I'll just do a normal reset. Mr. Turner, make sure you stay in touch with Ms. Cawthon. Once she gets that information from Mr. Coleman, you guys can meet and go over it, and then we'll see if we can get an announcement at the next court date. All right. Thank you. You're free to go. Thanks, Ms.
Thank you, Your
Cawthon.
Honor.
Let's see, is Mr. Cole here? Mr. Leish? On Carly Davis? Carly Davis Hoosier. Is there, Mr. Coleman, witnesses on this or just argument? Or?
And I forgot the message about the re-indictment. I'll just take care of that.
It's a mess.
It was.
I tried.
It was pretty convoluted.
All right, you're Carly Davis and Carly Hoosier. And this is 24 DCCR 1385 and 25 DCCR 1237. And so their state has, we were going to be here on reviewing bond conditions, correct? And then the state has filed a motion to increase the bond.
Yes, Judge.
And is that in both of the cases or just that one?
In both cases, Judge.
Let me pull this up. I know I took a look at it last week, but.
This one's Judge.
And so we've got both of these cases are driving while intoxicated, third or more. The first offense date is from May 6th of 2023. The second from February 10th of 2025. Give me just a second here. No, it's working, it's just working slow. So I've got some history with regard to prescriptions. Some of it's obviously very hard to read, but it looks like prescriptions for alprazolam and something called D-amphetamine. Okay. Can't tell the date. One of them specifically says no refills. I can't read the dates on these.
We can get better photos, Judge. She had had that prescription for,
All right, it shows it expires October 31st for the,
Judge, I had a number of questions about those photos myself. I mean, I'm not necessarily, well, I guess I am questioning the validity. This doctor that allegedly prescribed it, this Rajan Desai, there's either an Austin address or a Millburn, Texas address for this doctor. When I looked him up through the Texas Medical Board, and I'm just a little curious about.
so where do you go to the doctor? Where's this doctor from?
From Beaumont, and I do a telemed every month except every 3 months. I go to his office now. I don't know, putting it in today now.
Today?
Yes, ma'am.
Where specifically?
Telemed today.
Oh.
Yes.
Well, here's what I think I'm going to do based on the nature of what these medications are and the history. Well, are you driving? Okay, I don't know if I already did, but a condition of your bond is going to be, as of today, that you are not allowed to drive any vehicle ever, period. Okay, so if you're caught driving, obviously you'll be right back in jail without, probably without a bond. Mr. Coleman, other than a no driving, is there any other?
No, Judge, I just would like to reiterate, and we put it in our motion, and it sounds like the court's read the motion, but she's got 4 previous DWIs, Judge, and in addition, she picked up this latest DWI while out on bond for a DWI,
Right.
Judge. And that along with the positive drug test, I think the public safety, the community safety demands some additional assurances.
And Judge, our argument would be that the DWI itself is for the medications. She's been on these medications for.
Well, it doesn't matter if you're on medication and you're
Right.
taking too much medication, then that's a problem.
Sure.
So you can be on these medications and not be.
Also, the failure of the drug test was for these medications.
Right, I understand that. My biggest concern is the fact that if the medications are not being taken properly or too much of the medications, then that's a larger concern with the safety, and I completely understand and agree with Mr. Coleman on that. How'd you get here today? Here's what I want you to do, what I'm going to order you to do. I'm going to order that at your appointment, I'm requiring you to find out and with your doctor, get a prescription for something that is non-narcotic. So something that is not going to cause these issues, if in fact our concern is that you are misusing or overusing these medications, then there's other medications that you can take. You need to talk to him today. I want you on your way to be off of both of these medications and on something that would not lead to the issues that you're having. Does that make sense? You need to get that information from him, find out what he can prescribe. I want those to Ms. DeLage, and I want her to get those to me. That is a condition of your bond at this point. If you don't do that today at that appointment and get that information to her, then I'm going to, what I'll do today is not rule on Mr. Coleman's motion. So that motion to raise your bond is still out there. And if you don't get this information and you don't get this done today, then your bond will likely be raised and you'll be in jail. Do you understand? All right.
My only question is, the medication to get off of it abruptly can cause.
I understand that. I'm not saying you have to get off of it abruptly. I'm saying I want the plan and how you're going to do it, what it's going to be reduced to, what it's going to take its place, whatever it is. I want that. You need to tell him that you have been ordered to get off the medications, but obviously that needs to be done in a medical way, but I want whatever that plan is and how you're going to do that, and I want that to Ms. DeLay so she can get it to me tomorrow. Okay? All right, y'all are free to go.
Thank you, Your Honor.
Okay, thank you. See,
Diamond Jane.
Mr. Floyd? Is Mr. Floyd here? Mr. Choate, good morning. Good morning, Mr. Choate. This is Richard Afong Wade, 23-41318. Mr. Hoffpower, good morning. Good morning. You're Richard Afong Wade? And Mr. Afong Wade's case is set for trial to begin with jury selection next Monday. Again, what is everyone's announcement?
Unfortunately, we had to file a motion for continuance. Mr. Floyd had to have a partial knee replacement last Wednesday. He's under doctor's orders not to sit or stand for long periods of time. And so we had to file a motion for continuance. So I guess our announcement does not make sense.
I got the message, Judge. I don't have an issue. I mean, I can't get a motion.
Sure. Is there a timeline on that?
So in the next, I think he's got to follow up in 3 weeks, and then they'll reassess what he's allowed to do, right? Because like right now, he's still like at home.
Sure.
So,
Okay, so I'm going to reset the case to the next trial docket to give them plenty of time. Obviously, you guys know this was going to be the number one probably. It's really going to be up there next time. So as far as age goes, I'm going to set it, and if I need to protect everybody, I can do protection orders from other courts if you need that as well, because it'll be time to get it way past time next time.
yes, Judge.
Tell him I hope he gets better, and we'll see y'all the next trial docket.
Thank you, Judge.
You're free to go.
Appreciate it.
Thank you, Judge.
Let's go back to Florida. Judge Mercer is back in court, this time dealing with defendants in the courtroom instead of from the jail. So let's see what's going on there.
Does not appear to match what you're saying today, so I need to get a little clarification. Ms. Barfoot, come on up here. Ms. Barfoot, I've got in your case, number 2 on the docket, I've got $1,400 a month Social Security and veterans benefits. So what is your income, ma'am?
And the veterans benefits is $241 a month.
So what's your total monthly income, ma'am?
I'd have to do a pencil
Okay,
of paper.
well, go ahead and give one to me and I'll do it for you. What's your monthly income for veterans benefits?
241.
Okay, and what other income do you have?
The Social Security.
And how much is that?
Disability. I think it's 1,400. I'm not positive about it.
And the other thing I have not asked is, according to the notes, and this probably came from your first appearance paperwork, that you have $120,000 equity in your home.
Probably.
Okay, you're not going to qualify for the public defender's office then. If you own that much property, then I can't appoint a lawyer to represent you because you have too many assets.
That's not what's on the tax affidavit, though. 120,000. I don't think.
The taxable value has nothing to do with, I'm not gonna say it has nothing to do, it has very little to do with fair market value. Fair market value is how you determine equity, not taxable value. The tax value that they assess it for tax purposes is that's a system they use internally. So let me see where this information is coming from. Usually it comes from financial affidavit that you filed. And yeah, it shows $120,000 equity. This is a form you filled out. You don't qualify for the public defender's office. You simply have too many assets.
So
All I can do in that situation is reset you for next month and instruct you. I'm going to ask Mr. Mitchell to tell you what the state's offer was going to be, so you'll know that.
yes, sir.
And then you need to hire an attorney. You make too much. You have too many assets to get an appointed lawyer. What is the court date next month? Okay, and Mr. Mitchell, what was her offer? The state's recommended disposition?
Our recommended disposition was the same as the first appearance offer that she received at a couple days ago, which was 1129 probation, $370 fine, absolutely no contact with the victim.
So if you want to resolve it and take the state's offer, you certainly can do that. If you want to talk to a lawyer, you certainly can do that. And if you have questions, the better thing to do is talk to a lawyer and get your questions answered. Okay. So what I'm going to do, unless you tell me you want to take the probation, what I'm going to do is give you a notice for your next court date. Is that what you want to do? Okay.
Yes, sir.
So we're going to give you that.
Do I have to go to jail while
no.
I'm away?
No. You, looking at your status, you're on a cash bond. As long as you
Yes,
comply with the terms of your cash bond, nothing changes. We're just bumping your court date because you don't qualify for a lawyer.
Yes,
If you'll sign this notice, we're going to give you a copy of it, Ms. Barfoot. And once you get a copy of it, you'll be free to go. Okay?
Thank you.
Yes, ma'am. Ms. Barfoot, you will not get a notice in the mail.
Yes, sir.
That notice we're about to put in your hand will be the only one you get. Okay? Any questions? All right, have a good day, ma'am.
Thank you.
Yes, ma'am. Mr. Mickens, come on up. Mr. Mickens is number 18 on the docket. Mr. Mickens, the financial affidavit you filed shows us income quite a bit more than the income, not quite a bit more, a little bit more than the income that I announced. So, Mr. Mickens, are you employed?
No, sir, Your Honor.
Okay. What kind of income do you have?
I have a military disability and Social Security.
Do you know what they total?
Right at 26, 27, somewhere in there, sir.
Okay, yeah, $2,700 is what I've got here, and that probably comes from your
That's by the time
first appearance paperwork.
That's by the time I pay rent and light bill and food.
Okay, the current cutoff is 2608, and you make 2,700. Is that correct?
Somewhere in there, sir.
Okay, I'm going to qualify you. You're really close. I'm going to qualify you for the public defender's office. So just have a seat. Mr. McDaniel will talk to you shortly.
Thank you,
Okay.
sir.
Judge, we're going to do that's fine, but that is, tax-free money, so it's actually more, but I didn't know if he owned his house and owned his, okay.
What is tax-free money? Oh, you're saying that the 2,700 is tax-free because of the type of income it is?
Correct.
So it's really a lot more than
It's really a lot
2,700.
more than 27.
I didn't realize that was tax-free money.
Yes, veterans benefits is all tax-free.
I had no idea. So what would that equivalent be? You'd add 20 to 30%, 20, 25% probably?
25, 30% to it.
That is quite a big difference. So let me see. Just a second. Mr. Mickens. Let's just say it's 20%. Oh, yeah. So Mr. Mickens, that's going to change the analysis quite a bit. Let me take a look at your paperwork you filed when you got arrested on your financial information.
I can truly state I cannot afford an attorney, sir.
I'm sorry. Hand me that back, please. Your offer was 9 months in jail. That tells me you've got quite a criminal history to be made that offer.
If I may, Your Honor.
Sure.
The ticket, I only have one ticket in New York State. I got a letter from the court stating that all that's been expunged. Okay, the ticket I got in 93, 3 days later, I went to Germany. I wasn't evading a ticket or anything. I got a letter from the court stating there is nothing in the court system. It says you have to clear the National Registry. I have that letter with me today. There's nothing in the court system.
We're talking about two different cases,
Yes, sir.
apparently, because a police officer's report says you have 4 prior convictions, not one. January of 85, January of 89, July of 89, and August of 17. And that's just talking about your driving license suspended convictions. That's not talking about your other criminal convictions.
No, I mean, just
so-
driving.
So you have a extensive criminal history. At least that was what I was told at first appearance, or I would not have offered you or approved 9 months in jail. I wouldn't have done it without somebody saying he's got a bad criminal history or me seeing a criminal history. So you want to talk about a driving history. What I'm telling you is your overall criminal history has got to be pretty bad for you to be made that kind of offer. So you've got a choice. Since you're above the limit, you've got a choice. I'm going to give you a partial qualification for the public defender's office if you want. If you want to go hire an attorney, that's
I can't
okay
afford an
too.
attorney, sir.
So if you'd like to call to the public defender's office today, then you'll be assessed an additional $100 for today. If it goes to a pretrial, you'd be assessed an additional $250 for that. If it goes to a trial, you'd be assessed an additional $500 for that. Or you can go and talk to an attorney of whoever you wish and get whatever price you want. And I'll do like the last case and give you another court date. So the question is, do you want to talk to the lawyer while you're here today, knowing that you're going to be assessed $100 for that today, regardless of what happens? You won't pay it today. You'll be assessed that. And then you may choose to go hire an attorney after today's court date, or you can just skip that and say, I just want to consult with an attorney of my own choosing, and I'll give you another court date to do so.
I like to talk to you.
All right, so just have a seat and we'll appoint you with those conditions, appoint the public defender's office with those conditions. Here's the driving record back. Anyone else on this side of the courtroom that makes more than those amounts I announced, which are $15.05 an hour, $602 a week before taxes. All right, so now let me tell you the process we're going to follow for those of you on this side of the courtroom, and I'm going to talk to those of you over here in just a second. What we do in your cases over here is Mr. McDaniel is going to call you one at a time, and he'll talk to you in the jury room. As I mentioned earlier, there's no phones, there's no video in there. It'll be in private. He'll talk to you about what you've been accused of. He'll talk about any defenses that you have. In most cases, almost every case, he'll have a tentative offer from the state attorney's office. He'll talk to you about that offer to see if y'all can reach a resolution. If you can reach an agreement today, he's going to tell you to come back out and have a seat. And you'll see me again later this morning. Before you leave, you'll see me. We'll resolve the case and put the agreement on the record and make sure I'm going to accept the agreement. The case will be over with. On the other hand, if he talked with you and he realizes there's just too much of a difference between what Mr. Mitchell's asking for and what your position is, or if there's some defenses he needs to look into and investigate, he's not going to tell you to have a seat back in the courtroom. In that case, he's going to give you a written notice, which you will sign for, that will have a different court date, about 45 days off to come back. So that gives you 45 days to communicate with him, for him to research, look into the case, look into your defenses, and do a little bit of legal work, legal background investigation on your case. So either he's going to give you a notice for another court date, or he's going to tell you to have a seat back in the courtroom. Either way, do not leave the courthouse unless you have a signed notice from him with another court date that you've signed and you've got a copy of, or you've seen me up here at the microphone. If you do leave the courthouse and I haven't seen you, and he says, Judge, Mr. Johnson left without, and I don't know if any of you named Johnson, but I just picked a name there. Mr. John Doe left without seeing me, and he didn't see you either. I'm going to issue a warrant for your arrest. So your court date is not completed until you completed the court date process, not just showing up and leaving. You've got to stay and complete the process to satisfy that requirement. Next, if you want to talk to your attorney at length and in detail about the defenses of your case, I encourage you to do that, but that's not what today is for. Today is an arraignment docket. Mr. McDaniel, how many people do you have to speak to?
About 15, 18.
He's got to talk to 15 to 18 people. That means you're going to get 5 to 10 minutes at most. If you want to talk to him in detail, that's fine. Nothing wrong with that, but it's not today. Today is just to get preliminary information from you, email address, phone number, talk to you about the state's offer, get your side of the case, take some notes, move on to the next case. So don't think we're going to talk to him for 30 minutes today. That's just not possible given the number of people he has to speak to today. So lastly, Mr. McDaniel will usually call 2 or 3 names. The reason he does that is he'll have a couple of people sitting in the jury box. He'll take one in the jury room. When it comes time for the next case, they'll already be in the jury box. So if he calls 2 or 3 names, he'll give you some instructions on how to do that. Who all goes into that meeting in the jury room is up to you and Mr. McDaniel. Whatever he is okay with and you're okay with, that's up to y'all. If you got family here, you want your family to go in there, talk with them about that. And in most cases, that's not a problem, but you need to talk with your attorney about that. Mr. McDaniel, did I miss anything?
No, Your Honor.
Whenever you're ready, sir.
Ricky Barbeau. Ricky.
Judge, I just sent you a message regarding one, and I sent it to Don.
Jeremy.
Little typo error I noticed.
Thank you.
She's going to be the first one we call up when we're ready.
Thank you, Mr. Mitchell. All right, ladies and gentlemen, now let me speak to those of you on this side of the courtroom. Your cases are different because you're not asking for an attorney, so it's a different process we go through in your cases. So listen to the process we follow in your cases. Over here, in your cases, we're going to call your cases one at a time. When we call your case, I need you to come stand in front of the microphone. Mr. Mitchell or myself, one of us will call your case. When you come stand in front of the microphone, then you have to be advised of what you're accused of, and you have to be advised of the maximum penalty for that charge. You can, if Mr. Mitchell says this person's charged with battery and it carries up to a year in jail, he's not asking for a year in jail. He's telling you the maximum penalty for that charge, which by law you're required to be advised of that, the charge and the maximum penalty. So he'll tell you that information. At some point, different prosecutors do differently. I think Mr. Mitchell's preference is typically to go ahead and tell you what their recommended disposition is, what they're asking for. So he'll say, Judge, this is a battery case. We're asking for probation. He'll tell me that information. He'll tell you that information. At some point, I will ask if you have any questions about what you're accused of and how you wish to plea. There are three types of pleas entered in criminal court. There's a plea of not guilty. I'm assuming your plea is not guilty, because if it was not guilty, you'd be seated on this side of the courtroom. So first is a plea of not guilty. The second is a plea of no contest. The third is a plea of guilty. Here's the difference between no contest and guilty. A plea of guilty is where someone says, I'm admitting that I committed the crime I'm accused of, and I'm accepting responsibility for that crime. That's a plea of guilty. A plea of no contest is where someone says, I'm not saying I committed the crime. I'm simply saying I'm not contesting the crime. A plea of no contest is where someone doesn't contest the charge. I'm going to accept responsibility for it, but I'm not saying I did it. That's the difference between a guilty plea and a no contest plea. So I'll ask you your plea. You'll enter a plea of guilty or no contest, and then we'll move on to the next step. When Mr. Mitchell's making his recommended disposition, he does that based upon several factors. So in the prosecutors in these kind of misdemeanor cases, they have three things generally they can ask for. They can ask for a fine only with no probation, just a fine. That's normally a driving license suspended first offense. That's kind of the normal thing you'll see, something like that, depending on criminal history now. Or you can ask for probation with a fine. That's someone who's got a battery charge, usually going to be a probation with a fine. A first offense DUI is usually probation with a fine. The third thing he can ask for is jail time with a fine. And where Mr. Mitchell falls upon that scale depends upon several factors. He will look at the charge you're accused of. He's looked at your criminal history. If it's a driving offense, he's probably looked at your driving.
This is interesting, and I always love listening to Judge Mercer, but I'm going to preempt this because currently going on, and I'm getting this courtesy of KSTU and East Idaho News. This is a hearing for Tyler Robinson, the accused Charlie Kirk assassin. So let's peek in on that.
Calling the case 251-403-576, State of Utah versus Tyler James Robinson. Counsel, could you enter your appearances, please?
Chad Grunander, Jeff Gray, Lauren Hunt, Ryan McBride, and Chris Ballard for the state, Your Honor.
Good morning, counsels.
Good morning, Your Honor. Kathy Nestor, Michael Burt, and Richard Novak on behalf of Mr. Robinson.
Morning, Your Honor. Good morning to you all.
Good morning.
And to the jail. Do we have Mr. Robinson present?
Yes, Your Honor.
All right. Mr. Robinson, good morning to you as well. Counsel, as we begin, I have entered orders allowing the admittance of Mr. Michael Burt, Mr. Richard Novak, pro hoc vice, and appointing them along with Ms. Catherine Nestor to be Mr. Robinson's counsel. The court enters findings that the combined experience of counsel meets and exceeds the requirements of Rule 8. Counsel, do we have, what would we like to accomplish today?
I have two items, Judge. I just wanted to make a record that under Rule 16 of the Utah Rules of Criminal Procedure with respect to discovery, the state is required to provide to the defense within 5 days of the defense's request the discovery that we relied on in making this charging decision. We'll be prepared to do that, so we'll look for defense counsel's request or the next day or so, and we'll provide that to the defense.
Thank you.
We also, for the court's information, we met this morning with the defense team briefly in our office to talk about discovery and the process. So we'll be working together. There is a substantial amount of discovery in this case, Your Honor. It's voluminous, to say the least, and we're working on a process where we can exchange information as quickly as possible and be efficient in that process. The other item I had, Your Honor, I saw that over the weekend, there was a protection order, pretrial and trial publicity order entered by Your Honor. And I just was seeking some clarification on page 2, at the end of the first paragraph. It reads, "To that end, lawyers participating in the investigation or litigation of this case shall inform all witnesses, investigators, consultants, staff members, or other members of the prosecution or defense teams that the prohibitions contained in this order." The state, we're seeking some clarification with respect to the phrase "all witnesses," Your Honor. There are a number of witnesses that have yet to be identified that will likely be used in the state's case. This occurred in front of 2,000 to 3,000 students at Utah Valley University. So we're in the process of identifying those witnesses. And so those individuals are presently unknown right now. So we're looking for a little clarification from the court. And I suppose we're not going to make any arguments today, but there may be some follow-up pleadings that we may need to file.
Thank you. Ms. Nestor, did you want to be heard about that issue?
No, Your Honor, we would defer to whatever the court wants to advise them on that matter. I mean, I think it's fairly obvious that we don't know who all the witnesses are in this case yet. I think it's just important that if anyone is identified, that they have information about this order. So I think other than that, we wouldn't weigh in on any other matter.
Thank you. Well, thank you for that question. That's an important one. The court will rule that as the witnesses become known to each side, that information is conveyed to abide by this order. Obviously, there are potentially many witnesses, and so it's not the expectation that you would be able to do that up front, but as they become known, I would ask that you would inform them of this. Anything else, counsel?
Nothing from the state, nothing else, Judge.
Thank you. Ms. Nestor.
Thank you, Your Honor. We recognize that we are here today for a waiver hearing. It is not our intent to waive a preliminary hearing in this matter. We are going to be seeking that one be set. However, based largely on what the state just referred to as far as the voluminous nature of the discovery materials, we do think it would be prudent to simply reset for another conference, another waiver hearing, a little bit down the road, where we have a better idea once we start seeing the discovery as it rolls in. I do recognize we're going to be getting that first batch in 5 days, but it's my understanding from our meeting today that there is massive amounts of digital that is going to be coming. And until we can kind of get our heads around exactly what we're dealing with and how much we need to process, it's going to be difficult for us to give you a reasonable expectation of when we will be ready to do the prelims. So we're asking today that we put that decision off, and maybe we could check in 30 to 60 days and just kind of let the court know where we're at and how much we're looking at and how much time we may need to set a preliminary hearing. Also, as far as a detention hearing, we are not asking the court to address that issue at this time. Under the statute, the issue is going to come down to the question of whether there's substantial evidence, which right now we're just not in a position at all to be able to even argue to the court. So we are probably going to ask that the court delay that decision possibly until the time of the prelim. But if it's sooner, we will ask the court for a hearing. But at this time, we are not asking the court to make any decisions on that matter.
Thank you, counsel. In regards to the next hearing date, how about October 30th at 10 a.m.?
That works for the state, Your Honor. Thank you.
All right.
That's fine for the defense, Your Honor.
All right. Now, as we're at the beginning, anything further from counsel from either side?
No, Your Honor, thank you.
No, Your Honor, thank you.
As we are at the beginning of this case, it is my intent to only speak when I'm needed or it is necessary. But today I do wish to provide guidance and expectations that you can have for this court and wish to enter an order as well. As this case moves forward, Mr. Robinson's constitutional rights will be protected at every stage. He sits before this court presumed innocent, and that presumption remains unless and until each element of every offense charged against him is proved beyond a reasonable doubt. At the same time, and as applicable, victims are entitled under our Constitution to be treated with fairness, respect, and dignity, free from harassment or abuse. Justice demands that both of these principles, the rights of the accused and the rights of victims, be honored without compromise. I remain steadfast in my oath that I made 56 days ago to support and defend the constitutions of the United States and of Utah. I will carry out my duties with fidelity, transparency, and impartiality, treating every person who appears before me with the dignity and respect they are inherently due because they are human beings. Let me be clear. I will not put my finger on the scale of justice. These proceedings will be open to the public, conducted in accordance with the law, and handled with diligence and competence to ensure that justice is never compromised. It is the standing order of this court that Mr. Robinson shall be allowed to appear in person so he can fully engage with his attorneys and participate in these legal proceedings. Counsel, regardless of who is watching, whether it is the nation or a single individual, we must fulfill our roles with integrity, civility, and diligence. I encourage each of you to give your very best to this case. Neither Mr. Robinson nor the people of Utah deserve anything less than the fair and impartial administration of justice. In regards to the next hearing, counsel, on that October 30th date at 10 a.m., it's the court's intent that be in person if it be the wish of counsel for the defense for Mr. Robinson to be present.
It is, Your Honor. Thank you.
Thank you. Counsel, anything else that we can address today?
Your Honor, we appreciate the court's comments with respect to Your Honor's role in this case. In like matter, we commit to approach this case with integrity, with professionalism and civility. We are truth seekers. We will aggressively pursue the truth in this case. Thank you.
Thank you. All right, counsel, unless there's anything else, thank you for being here. This court is in recess.
Okay, so we learned a couple of things there. First, we learned this judge is apparently a rookie. Heaven help him. That's getting thrown in at the deep end for sure. There was talk in the chat about a waiver hearing. I think what they were talking about was waiving the prelim exam, which the defense was clear they were not going to do. And it sounds like this judge is going to go by the book, but we'll see how that goes, just like everything else. Let's go to Judge Boyd, 9 to 11% more of her.
State versus Joseph Alamon. Could I have parties announced for the record?
Adam LaHood for the defendant, Your Honor.
And are you Mr. Alamon?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I have, and we did receive it, Judge.
Court will find that the state is in compliance with discovery. Mr. Alamon, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We have no objections, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
No.
All right, the state is proceeding on the lesser included offense of assault bodily injury as a Class A misdemeanor. The range of punishment is up to a $4,000 fine and up to 1 year in the Bexar County Jail. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, he's competent and was sane.
Mr. Alabon, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand by entering this plea, if you're not a U.S. citizen, you could be deported, not allowed naturalization, and denied re-entry into the country? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 365 days in the Bexar County Jail. The state is proceeding on the lesser included offense of assault as a Class A misdemeanor, and there's a $2,000 fine. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that there be no contact with Stephen Blackstone or Savannah Villalobos. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, court will find there is sufficient evidence to find you guilty. And the court will find you guilty. State, have you had a chance to speak with the complainants? Have you had a chance to speak with the complainants? Okay. All right, thank you. All right. Are you waiving PSI?
We are, Judge.
Anything you wish to say on behalf of your client?
No, Your Honor. I know the plea calls for 365 days. I believe he has over 250 days or so, about or thereabouts. We're hoping the court will see fit to judge him satisfied.
All right. So I'm not going to judgment satisfy you because you don't have 365 days. The Bexar County Jail, they're in charge of people receiving 2 for 1 or 3 for 1. Usually if you're in general population and there have been no issues, for every day you serve, they'll give you credit for 2 days. If you're a trustee, for every day you serve, they'll give you 3 days. The only thing that can stop them from giving you 2 for 1 or 3 for 1 is their own rules and regulations, right? Or I can tell them, no, I want you to serve the full 365 days with no 2 for 1 or 3 for 1. Do you understand? So what I can tell you is the most time you will serve will be 365 days. Do you understand? All All right, as previously stated, the court is finding you guilty. The court will sentence you to 365 days in the Bear County Jail. There's a $2,000 fine, time and money will run concurrently. The court will give you credit for any time served. There's to be no contact with Stephen Blackstone or Savannah Villalobos. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. Here's the thing. When you go to somebody else's house and y'all are drinking and it's a house party, just leave before anything happens. You understand? All right, good luck to you. You're welcome. All right, anyone else?
All right, let's go to Reno. Shelley O'Neill doing first appearances, I believe.
Moment to get my computer back on track here. You filed a motion to request that the city pay for a competency evaluation for your private client. The case is 25 CR 09684, Amanda Ann Leitonen. Ms. Leitonen, good morning. Good morning, Ms. Leitonen. Is your microphone muted?
Yeah.
Okay. Good morning to you.
Good morning.
So, Miss Desmarais, is that how we pronounce your name?
Yes, Desmarais, Your Honor. Thank you.
Thank you, Desmarais. It's very pretty, and you can tell it's French. I have previously denied your request to have the competency evaluation happen at public expense. When your client has the means to retain private counsel, then she or her family should be able to afford a competency evaluation. So I have denied your motion. Is there anything else that you require?
No, Your Honor, and I apologize. I believe that was a miscommunication between me and Mr. Davies in reading the docket. I thought the court had already approved the eval and that we just needed to arrange the evaluators. I will flesh that out on our end. I don't think that issue will be resolved this morning. If something else comes up, I need to file a separate motion. But I am in contact with Ms. Leighton's mother, and I do believe that I should be able to work it out with her just based on my.
Very good. All right. Well, I'm sure that bail has been set in her matter. Let me confirm that for you.
My understanding is that she's currently on a no bail hold.
Yes, you're right. It was issued on September the 2nd, 2025. And looks like you filed in August the 12th as private counsel. But I would like to have this matter. It sounds like Ms. Leighton has been sitting for a while on an obstructing and resisting a police officer by non-compliance from July the 12th. That's a pretty long time to be held in custody. So let's get this matter moving one way or the other.
Would the court entertain reinstating bail?
Yes.
Ms. Leighton, I'm in a lot of contact. I know this is third hand, Your Honor, or second hand at least, in a lot of contact with Ms. Leighton's mother, who's very involved in her life. Prior to this incident, Ms. Leighton was living with her mother. She's very involved. She calls the office frequently. My understanding is that she is comfortable financially, and so she would be able to make the bail if it was returned to that $1,000 bondable. She also is in a position to afford the competency evaluations. I know that the evaluators can do them if she's out of custody. It would just be, I think, if there are going to be, I know Mrs. Leighton's mother had expressed to me a preference for her current provider to do the competency evaluation. I would imagine that would be faster and quicker out of custody. I'm not sure that evaluator would be approved to go through the jail. So I think just a little bit of these hiccups might be ironed out if Ms. Leighton was reinstated on bail and able to bail out.
And what's the city's position relative to reinstating bail? I'm really concerned based upon the gravity of this case that she's been in custody quite some time with mental health issues. Do you have any objection to the court reinstating the $1,000 bail?
Your Honor, I'm sorry, Your Honor, I interrupted. I am not in a position to object to that. I would add that looking at the history, it looks like she had a bench trial date set on September 2nd. She was represented by a legal defender. A competency evaluation was ordered on September 2nd. And what the court generally does is when there's a competency evaluation ordered and somebody's in custody, they're placed on a no bail hold. And I don't know where that competency evaluation went or whether it actually happened. So because the issue of competency was what kept her in custody, I'm not going to object to resetting bail.
Thank you. So I think that this is one of those matters where, because she was represented by a legal defender initially, that a competency evaluation would have been ordered for her. Now that she has private counsel, I'm going to go ahead and reinstate the bail at $1,000 bondable. And let's try to get a competency, if we can, Ms. Damaris, on within 30 days so we can set this matter, get this matter back on track. Obviously, if she's found to be incompetent, the charges would be dismissed. And I don't want her to be held in legal limbo because she retained private counsel.
Thank you, Judge.
All right, so Ms. Lattinen, we're going to go ahead and set your bail at $1,000, and you need to maintain contact with your counsel. Do you understand? All right, that'll be my order.
Your Honor, would you like to set a pretrial hearing? We don't want to lose the case if she bails out.
Yes, that's a great idea.
Okay, I have November 4th at 8 a.m.
And is that a good date for you, counsel?
That works for me, Your Honor. Thank you.
I will go ahead and set that. So we'll see you back here, Ms. Layton, November the 4th. And please communicate with your counsel, do whatever they instruct you to do, okay?
Yes, sir.
Thank you, Judge.
You're welcome. All right, I think that is private counsel. Now I'll go on to the jail's special attention list. And the first person I have on that list is Tristan White.
Hello, Judge.
Good morning.
Good morning.
There we go. Mr. White, your case number is 25 CR 04833. I'm pulling up your case now, sir, and it looks like you were charged with basically littering, unlawful dumping of garbage, rubbish, or waste matter on April the 3rd. You were given a citation probably to appear at community court, and it's alleged, sir, that you failed to appear on April the 9th. Did you appear for court on April the 9th, sir?
I was detained under arrest in jail.
So you were, where were you in jail, sir?
Your Honor, on April 3rd. Yeah.
Hold on, Deputy O'Connell, you have the floor.
He was arrested April 3rd, Your Honor.
All right, then I'll go ahead and quash the outstanding warrant. And because obviously he could not appear on April the 9th if he was in custody. Mr. White, do you want to enter a plea to the charge of littering, basically unlawful dumping of waste?
No contender.
Okay, sir, and you understand by entering a plea of nolo contendere or no contest that the court will find you guilty of that charge?
Yes, ma'am.
Do you have any questions about your constitutional rights, sir?
No, Your Honor.
All right, the maximum penalty for this offense could be up to 6 months in jail and or a $1,000 fine. I'm proud to say I've never put anybody in jail for littering. But you understand that could be the maximum possible penalty?
Yes, Your Honor.
And have you served in the military, Mr. White?
No, Your Honor.
The court will accept your plea of no contest as freely, voluntarily, and knowingly entered. Are you there on other charges?
Yes.
Your Honor, all of his other charges are done.
Oh, okay. All right. Well, then we'll go ahead and I'll sentence you to time served in the Washoe County Jail and release you. Please be more careful about what you do with litter so you don't have to come back to jail, okay?
Yeah, thank you.
All right, you're welcome. Michael Hart.
Your Honor, he was taken back to his unit.
Thank you. Giselle Medina Cordoba. Did I pronounce your first name, Mr. Correctly, sir?
No, it's all right, miss. It's pronounced Asael.
Asael, thank you. I always want to get it correct. I think that's the way that you show people respect, is to at least pronounce their names correctly.
No offense taken.
Mr. Medina Cordoba, you were charged on September the 26th, 2025 with the crime of simple battery. Did you
Yeah.
understand this? Did you understand the charge, sir?
Yes, yes, ma'am.
And is it your intention this morning to enter a plea of not guilty and schedule the matter for trial?
Not guilty, correct. Correct.
All right, I'll accept your not guilty plea, sir. We'll set the matter for trial. Can you afford your own counsel?
Yes.
All right, we'll go ahead then and set the matter for trial. May I have a trial date, please, for Mr. Medina Cordoba?
Yes, Your Honor. That would be November 4th at 1 p.m.
All right, so Mr. Medina Cordoba, your trial date is November the 4th at 1 p.m. So you'll need to go ahead and contact a lawyer and get that lawyer on board as soon as possible, so you can get copies of the discovery, which are the police reports and witness statements, okay?
Okay, sounds good. I will do that.
All right, the other thing I want to talk about is bail. A bail was set on September the 28th, which was a Sunday. So,
I declined it.
okay, it's your bail set at $1,000.
Holy shit. $1,000?
Yeah, since,
Oh my.
hold
Can I
on,
do- can I
Mr.
do
Medina,
payment?
hold on, listen to me for a moment, okay? That is a bondable amount, which means that you can put up a small percentage of that to get out of jail. The bail bondsman usually keeps the money you give them, could be 10 or 15%, but then they carry the balance, so you can get out of jail and get back to work. Can you afford to bail out, sir?
I can't afford the full payment, but I can afford increments of $250 every week. That'd be
Okay, well,
sweet.
you can work that out with the bail bondsman. So have a family member or a friend contact your bail bondsman. Your bail will remain in effect.
My family will not help me. They have officially abandoned me, so I'm on my own.
Okay. All right, Miss Burning, do you wish to be heard here?
Yes, Your Honor. I would be asking on behalf of Mr. Medina Cordova for he works
At a bakery.
at a bakery, at a family bakery, as I recall.
Yes, ma'am.
And so he does have work. It's the Jalisco Bakery in Sun Valley. He and maybe Mr. Medina Cordova, you'd have to come up with $100 or maybe $150 to bail out. Not the $1,000.
No worries, miss. I'll do my time. I mean, if I can work here.
No, listen to me. Listen to me. So you were offering the court a minute ago to pay things in increments of $250.
Yes.
$250 is more than probably the most that you would have to pay to bond out. Do you
I just don't have it
understand that?
on my credit card or in my wallet. I
So
have
do you have a
$60.
friend who could help you?
I have no one, miss. Unfortunately, I have no one. I'm abandoned. Yeah, just simple as that.
So your choice.
So
We
I will
talked
serve
about
my
this
time,
case.
whatever I gotta do, I'll serve it. No hassle.
Well, the question I think the judge is going to ask you, sir, is if you want to maintain your not guilty plea, that
What would
you're
you-
not. Well,
What-
we talked about this
Not guilty.
before.
Not guilty.
Yes.
Okay. Sounds good.
Thank you.
Thank you.
All right, well, I'm sure that there's someone at the jail that can speak to him about the possibilities of release. I know the jail's quite crowded. Did the city want to weigh in at any time regarding this issue, Mr. Boyd-Stanner?
Your Honor, I would just add that he did score a 5 on the MPRA. He doesn't have, he's unemployed. He reported that he's supported by others. He has been living in Reno for the last 23 years. And there is a note in the pretrial assessment report indicating that the police report was reviewed and defendant was overwritten due to possible mental health concerns. He's here on the allegations that he pushed a security officer at Renown. So all of those facts support that $1,000 bondable is appropriate. Thank you.
Thank you. All right. So Mr. Medina Cordoba, you can make the decision personally about whether or not you want to stay in custody or bail out. In the meantime, we've set your trial date for November the 4th at 1 p.m. And based upon what I have heard, I'm going to appoint a legal defender to represent him because he's indicated that the NPRA indicates that he was not working. Now, he told his counsel that he is working, but based upon what I've heard here today, I frankly think he could use counsel. So I'm going to go ahead and appoint a lawyer to represent you, Mr. Medina Cordova, and I'm going to order that you make contact with that lawyer in the next week or 10 days, okay?
Thank you. I appreciate it so much.
All right, sir.
That's fine.
Your Honor, is there any testing or a no contact order involved in this?
Hold on a minute, Mr. Medina Cordova. I'll hear from the city.
Thank you, Your Honor. I would ask that the stay away order be entered for Renown unless there's an emergency, and a no contact order for the security officer involved. His name is Kevin Rios Torres.
Sorry about that.
All right. So, Mr. Medina Cordova, I have appointed a lawyer to you. What lawyer would that be, please, Miss Massey?
That would be Mr. Puentes.
All right, so I have appointed a lawyer by the name of Roberto Puentes to represent you. You need to contact him as soon as you're released from custody. So you can talk, and the jail usually would give you his telephone number and email address. Hold on. If you don't get his telephone number and email from the jail, you may contact the Reno Municipal Court and we will give you his contact information so you can make contact with your lawyer. Do you understand that?
I understand, miss.
All right. The other thing is that I'm going to order you stay away from renowned hospitals.
Yeah, they trespass you for some reason.
All right. So you know what happens if you go back.
Yeah, of course.
Now, if you have a medical emergency, that I'm going to waive any of the stay away order if you have a medical emergency only. So don't go back there for any other reason other than a medical emergency. And then I'm going to order something called a no contact order for you, sir. And that is to have no contact whatsoever with the security guard you're accused of pushing. His name is Kevin Rios Torres.
I did. I was angry at him because he treated me
Okay,
like.
don't make any statements relative to your guilt or innocence. You're presumed innocent. You've entered a plea of not guilty. Do you understand the conditions of your release?
I understand, miss.
All right, and are we looking for any kind of testing, Miss Apoitis Tanner?
Your Honor, I don't have anything in the probable cause statement indicating that he was under the influence of drugs and alcohol, and he's not employed. So with both of those things together, I'm not going to ask for it. I would ask for just a general no drugs and alcohol clause.
Thank you. So your conditions of your release, Mr. Medina Cordova, are these: that you obey all laws. You have to stay out of trouble. Do you understand?
Of course, of course.
And the other thing is that you have no alcohol or drugs of any kind other than that which are prescribed, and no marijuana while this case is pending. If you test positive for drugs or alcohol, I'll bring you back and you'll stay in jail until your trial date in November. Do you understand?
I understand, miss.
All right, that'll be my order.
Thank you so much.
Okie dokie, friends. Let's head back to Judge Boyd.
All right, have the interpreter come, please. All right. So where are we on discovery? Okay, let me pull it up. Thank you. Any objections to the court reviewing the summary?
No objections, Judge.
Judge, I don't believe you have a court summary. I do have the latest supplemental report
All
that
right, if I can have that.
That'd be perfect.
Thank you. All right, so there's a recommendation for you. the recommendation. And Miss Abrams
Yes, Judge.
and felony drug court, they're full still?
Judge, let me confirm the outcome for the larger.
So we're gonna see what the outcome was for felony drug court. The last time felony drug court was full.
Yeah.
And that was previously recommended for him. And for me to recommend that, that means that there's some issues. So everyone wants you to be successful at probation, and you're not gonna be successful if you don't get control of this drug issue. Yes?
I'm gonna print out that.
All right, thank you. Because there's a recommendation for you to go to SATA.
There's, Judge, we wanted to address that.
Okay. All right, so it appears that the prosecutor in felony drug court did not want you in felony drug court, so they believe there are other issues. Also, they were full at the time. But felony drug court and the TAP evaluation is recommending inpatient treatment. They're recommending either you go to lifetime recovery or you go to SATA. And you wanted to address that?
Judge, we wanted to, well, he was placed on 5-6 years deferred, approximately 90 days. He had the TAP done in custody.
Mhm.
And he's been a reliable trustee. He worked 6 or 7 days trustee in jail. He wanted to have the opportunity for outpatient treatment potentially because his father's in Northeast Baptist Medical. He's 82 years old. He knows this information because he calls his father's cell phone, and family members or have told him, you know, what the situation is right now. His prior, he had one prior approximately from the top of my head 10 to 12 years ago, deferred, successfully completed it. So what we would like to do is to place him in an outpatient treatment program with any and all conditions to monitor to make sure he's not doing any drugs or anything like that. He assures me that he will do whatever the court wishes to do on that front. I'll also want to give him an opportunity to speak to address the court.
So here's the thing. I'm reading the supplemental report and it says that you're not in agreement with the recommendation because you don't feel you were given an adequate opportunity in court to be allowed to explain your circumstances. The explanation of your circumstances is the TAP evaluation. And the TAP evaluation is done by experts and they feel that you need inpatient treatment.
The TAP evaluation was done after I'd been incarcerated for about 20 days, and I'm not really someone that's like been in jail before like that, so I feel like my answers were the fruits of my frustrations and just like not really actually bearing the truth, you know. So I mean, like,
No, here's the thing. No, when people do these treatments and they say, oh, I'm in inpatient treatment, or I've been without drugs for 20 days.
yeah,
When you're a heavy drug user, the reason why you're not using drugs is because
well,
at the Bexar County Jail, I'm sure there are ways. However, you haven't found those ways and you're on lockdown.
understood. The thing is that like I really feel that these 3 months being in jail, I've like kind of opened my eyes and like really made me understand where I want to stand as far as like what's
But
the
Judge
law.
Rennie says you've been on probation before, so haven't you always known where you should and did not want to be?
I admit I'm not perfect. I mean, I completed my probation. I feel like I'm a perfect candidate for probation because I completed it before. And I mean, I just feel that like an inpatient program would be more hurtful than helpful just because of the fact that my dad's in the hospital right now, not doing very
So
good.
here's the thing. Why didn't you think of that all before you committed offenses? And the perfect candidate for probation is someone, if they were previously on probation and they really learned things, they would not have another probation after the fact.
It was, my mom passed away and it was a poor judgment, poor choices that I made.
Now,
And
see, here's the thing. People need to stop blaming
yeah,
their choices on outside actions.
Judge, I will say that prior was over a decade ago. So, but he
I had a
he
business-
manages, I'm sorry, he manages commercial properties. He's got a full-time job as a, what's your full-time job?
I work at newspapers and education. I'm a community outreach coordinator. We call businesses, trying to get them to donate to schools around the area.
So he's got a full-time job, Judge, waiting for him. You know, I know the court is not too sympathetic to that, but at the same time, with alternatives, if he were in outpatient treatment and he was tested bi-weekly or something like that, you know, I think that would assure the court that he's not doing any type of drugs. So
Well, I'm always sympathetic and empathetic, but I still look at things objectively.
Judge, the last thing that's on my mind right now, like really, like I feel like if I can be with my father during this time of need, it would give me some like peace of mind. Because I mean, if I have to do inpatient program and I can't be with him, it will really just send my life into a downward tailspin.
Well, I see, that just tells me you don't know how to cope with things in your life, because if something bad happens, that doesn't mean your life goes in a tailspin. Let me use drugs.
No.
Probation, what are you requesting?
Judge, based on the supplemental report that was submitted, the option one was to hold Sadaf in abeyance and for him to do intensive outpatient treatment, monthly UAs, and sober support meetings. I'm not opposed to that. I would say instead of having it monthly UAs, maybe we put him on the IVR hotline and intensive outpatient. And then sober support meetings daily for 60 days. With the understanding that if anything happens, any positives or anything comes up, then he would go into inpatient treatment.
No, if any positives or anything comes up, a motion to revoke is going to be filed.
He understands that, Judge.
All right, the court will alternate meeting conditions. It's going to be the IVR hotline until further notice, 90 sober support meetings, and 90 days in intensive outpatient treatment. Is there anything else you need from the court?
We thank the court.
All right, thank you. All right, and then, hi. Oh, I'm doing great. And let me see, what was the name of that person, Miss? All right, Jonathan Navarro. And we're recalling him tomorrow, correct?
That's correct.
All right. Your previous attorney, Mr. Trevino, was appointed to represent you, but he is not on the list to receive appointments for first-degree felonies. So there is a mistake in the system where he was appointed. We're going to bring you back tomorrow, and we will make sure that there's an attorney here for you who speaks Spanish and who is on the first-degree appointment wheel. Do you have any questions?
Why am I getting first degree?
Because the case that you've been indicted for is a first-degree felony. And it's best that you speak to your attorney who's going to be appointed to you about the charge and any evidence the state may have.
All I can say.
Que me comparen las edades, que miren bien los mensajes.
To compare the ages, to look at.
No, no, no. Here's, do not talk to me about what you think the facts of your case are. That you'll need to speak to an attorney. We will bring you back tomorrow and you can address it with that attorney. All right, thank you.
Your Honor, may I be excused?
Yes, you may. Thank you so much.
Thank you.
Okay, I am ready. Crystal Velaz. Yes. All right, the court is calling 2025 CR 006953 State versus Crystal Velas. Could I have parties announced?
Daniel Gutierrez for the state.
Roberto Ambrosino for the defense.
And are you Ms. Velas? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Did you review the application for deferred adjudication with your attorney? Did you understand it and did you sign it? Did you review the true bill of indictment with your attorney?
Yes.
Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
To the clerk, do you have a copy of the indictment?
Oh, you know what, Judge, I'm so sorry, it was a long document,
Okay,
59 pages. So it's right here for you.
all right, thank you.
Yes, ma'am.
All right, counsel, you're waiving the reading of the indictment?
Yes, Your Honor.
And state, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, did you review the court admonishments? Oh, do you guys need anything?
No. I think I put, there was a restitution document. I think I put it in the plea paperwork.
Yes.
Just to give it to my client.
Do you all need this?
I think I need to give it to her to pay.
Okay,
This is my mistake.
that's okay. All right, did you review the court admonishments with your attorney? Did you understand it? All right, let's go off the record. Are you all only charging on count one because the court's docket has 3 different counts in it?
There's 3 counts in the indictment, Your Honor.
So are you proceeding on all 3 counts?
All 3 counts are part of the plea, yes, Your Honor. Maybe it's like 2 of them need to be closed out, they're separate in Odyssey, is that what you're saying?
No, I mean, if y'all are proceeding on all 3 counts, then y'all need to, so that the record can be clear and so that we're off the record, so that the record can be clear and she can know what she's pleading to. If y'all are proceeding on counts 1, 2, and 3, do y'all agree there are 3 counts?
There is, I mean, it's supposed to be deferred, so I mean, it should.
No, I mean, she'll need to enter a plea to all 3 counts, and if all 3 counts are the same level felony,
Yeah.
y'all need to put it in your plea paperwork. Okay, so if y'all will step back, and when you all are ready, I will take you out. Thank you. Anyone else ready?
Yeah.
Well, unfortunately, friends, we've reached that time, so whatever happens there will happen, but we won't be able to cover it. But never let it be said that we don't see just a variety of things here at the Courtroom Files. We had everything from littering to a hearing for an alleged assassin. So, and everything in between. Another crazy day here. So let's do it again tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. I have been forgetting to shout them out because, frankly, we've just been really into court, but do consider this channel's sponsor, Aura, aura.com/TCF. If you are not signed up for them, give it a try. It's 14 days for free. Long story short, there's a saying out there, and that's that if something is free, you are the product. And we all take advantage of free things, but those free things collect our data, and then our data ends up with data brokers, and then data brokers sells it to bad actors, and then your stuff is everywhere and bad things happen to you, potentially. But Aura cleans all of that up for you, so give them a try. It's 14 days for free. It's definitely worth a look. Aura.com/TCF. So help yourself out, protect yourself online, and support the people that support the channel. Again, we'll be back tomorrow. I look forward to seeing you all then. Please do have yourselves a great Monday, and take care. God bless.